seated. We're back on the record. We have the jury back with us. Good morning. Everyone had a restful weekend. We're going to get started. We were still with cross-examination with Ms. Tristan. Mr. Goss, you may proceed.
Yes, Your Honor. So, Ms. Tristan, when we left off on Friday, the jurors heard you on recording from July 24th, 2019, speaking to Ranger Bradley Freeman. You remember that?
Yes.
And on that recording, I just want to give some context to how the recording came into existence. So on that day, July 24th, there had been a plan between you and Ranger Freeman to have him call into the constable's office and make everyone there, and especially Michelle, aware that he was requesting you to go and speak to him. Is that right?
Yes.
And the purpose of this was not so you could actually go talk to him as a witness from the constable's office. The purpose was so that he could let her know that he wanted to talk to you so that you could see what she said in response to that.
Yes.
Right. And so the whole thing, it was, I guess I'll call it a ruse or a trick that basically for the purpose of trying to figure out how is she going to react if she knows that Ranger Freeman wants to talk to you.
Yes.
Okay. So your observations of how she reacted to that was the most important thing about this thing that you were doing that day with Ranger Freeman.
Yes.
Okay. So on direct examination, when the prosecution brought this up, they attempted to have you clarify that it was not Michelle that said it, but it was Chief Anthony Castillo that said it. Is that right?
Correct.
All right. And in order to do that, did they bring you in and play you the recording?
Can you repeat that question?
In order to help you clarify for the jury or to tell the jury that Chief Castillo said it, did they play for you the recording?
Yes.
Okay. And what day, if you remember, did they play you this recording?
I don't remember the day, but it's been, I've heard it before, the recording.
Is it since you came from Seattle to here to testify?
I remember from that day that Anthony Castillo said that, but I said it as an overall for the Vela administration.
Okay, and I'm not getting to that yet. What I'm getting to is, do you remember, was it after you came here to testify from Seattle in the last week that they played for you that recording?
It was after and before, so I've been hearing that recording.
So they played that recording for you several times?
Yes.
Okay, and did they explain to you that it was important that you tell the jury that it wasn't Michelle, that it was Chief Castillo instead?
No.
Okay. So let's talk about on the recording, and this is the recording that we're talking about is there was a time when you had the wire or the recording device on you during the day while you were at the precinct before Ranger Freeman called on this trick that he was doing, right? Mm-hmm. Is that a yes?
Yes.
And so there was actually a recording made of the phone call that he called in on, right?
Not the phone call. It was what was said in the office.
Well, sure, but he was also, you said that he was
it was a speaker.
He was put on speakerphone.
Yeah.
And so on that device, you could actually hear him calling what he said, the fact that he wanted you to come over, and then after that, you can hear a conversation that happened in, I guess, an office or whatever. Is that right?
Correct.
And so in that office, Michelle was in there.
Yes.
And Chief Castillo.
Correct.
Did you say you weren't sure who the other person was? Was it Minor? Lieutenant Minor?
Minor and Mark Garcia.
Minor and Mark Garcia.
Yes.
So there were basically you and what you have called and what you've identified for the jury as the administration.
Correct.
All right. And so what you testified to on direct was you said that Chief Castillo said, tell the truth, you don't have anything to worry about, we did nothing wrong, right?
Correct.
And when Michelle was there, she agreed with that.
She was just there. I don't remember her response, but she was just quiet in the corner.
Well, she actually said, and she said, when Chief Castillo said that.
The testifying for the witness.
Just the question's the same.
And whatever, so when that happened in that room, and Chief Castillo says this, and Michelle is there, whatever that is.
I'm following your words.
No, I thought you were trying to
It's
do
the way I
it.
think. No.
Okay, so what you were actually saying is, I guess, when Chief Castillo said what he said, and Michelle is in the room, and the people are in the room, and making this statement to you, Michelle didn't say, actually, hold on, give me and Susan the room. She didn't say that, did she?
No.
She didn't say, well, here, I need to talk to Susan alone, and then sit down with you and say, look, I need you to not talk about some of this stuff with him. She never said anything like that.
No.
Okay. And that's what Ranger Freeman and you were hoping that she would say. That was the point.
Objection, Your Honor, that's speculation.
Okay, that was what you were hoping she would say.
Can you rule on me?
Oh, I'm sorry.
Overruled.
I apologize. And that's what, because that was the plan to get her to say something incriminating, that would be the kind of thing that the plan was designed to catch, is her trying to influence you or to tell you what to say to Ranger Freeman.
All I know was just regarding Rodriguez Park. After that, I don't know.
Well, I mean, what I'm saying is you know that you've already testified that you and Bradley made a plan together.
Correct.
And the plan was have him call in, have her know that he wants to talk to me, Susan, Miss Tristan, and then see what she says and see what the response is. Right? That was the plan.
Correct.
So kind of like kicking an anthill and kind of seeing how the ants all scurry out of it and see what happens.
I don't recall what it was for, but I know it was just regarding Rodriguez Park and the response. But other than that, that's all I know.
Well, then here's what you also know, because you just heard yourself and the jury heard you on Friday. You know that with that plan in place, and after that conversation in the office, but regardless of who said it, in your mind, knowing that the most important thing you were going to do that day as part of this plan was to go to Ranger Freeman and tell Ranger Freeman how Michelle reacted to this. You knew that that was the thing that you were there to do, right?
Yes.
And when you got to Ranger Freeman and he said, what did she say? Regardless of who said what, in your mind, you believed at the time that Michelle wanted you to tell the truth, nobody did anything wrong, and that she didn't have anything to worry about.
I just said what was said as an overall, and I just let Ranger Freeman know that day. In regards to the truth, Anthony Castillo said those words. So I was letting him know everything that was going on inside.
I know, but when you let him know everything that was going on inside in your mind and in your heart and your brain told your mouth the words. She told me, be truthful. She told me, you don't have anything to worry about. She told me, we didn't do anything wrong. That's what she said.
At the time when you're speaking to somebody, that's, of course, you're speaking to somebody and you're just letting them know what was going on. I should have been an overall, but I was just talking with him that day.
Understood. And when you were just talking with him, and he didn't realize that the recorder was still on, you said those words in regards to Michelle specifically, didn't you?
I did say those words, but
In regard to Michelle specifically.
yes, but it was an overall for an overall administration.
I understand. So then her overall administration was run by her, right?
Correct.
Okay. And so you understood that sentiment, that thing that you needed to tell the truth was coming from all of them, including Michelle.
Yeah, it was done by Chief Castillo at the time.
I understand that, but what you're testifying to the jury, and I just want to make it clear, is that regardless of who said the words, you understood that Michelle, as well as the administration, was telling you to go tell the truth. We did nothing wrong. You don't have anything to worry about.
At the time, it was a word to me, so for me, I felt like there was something, so I just let him know what was said, but
And you chose Michelle as the person in your mind who had said that.
because she runs that office.
So you believed that Michelle wanted you to tell the truth. That's what you believed based upon the conversation you had with her and her administration.
That was a word that was said, so I just let him know that was said, but
And you let him know that that was said, and when you let him know that, you said Michelle said it.
Your Honor, I'm going to object to this having been asked and answered numerous times. She's already said, that's what she said. We already heard what she said on the tape.
Your Honor, the
How many
state-
times do we have to do this?
I'm sorry, may I respond?
Yes.
The state attempted to do this on direct examination and do this clarification. And the witness continues to keep trying to pull back from the point I'm trying to make, which is that when she had the opportunity to say it, she said that she said it. Regardless of who actually said it, that's what she believed and thought, obviously, because that's what you convey. And that point is what I'm trying to get before I can move on, and I will move on very soon.
He's trying to make the witness change her testimony and change her mind, and she hasn't.
No.
Overruled if you ask her one more time.
So what I'm saying is, she ran the office, is what you said. You had one job. Your one job was to go tell him your feelings about how she reacted after he made that phone call and after he kicked that ant pile. What did she react? And you're in that one job, when you had that one opportunity, what you told him was that Michelle said. So all I'm saying is that was your feeling about how that interaction went, is that Michelle wanted you to do those things.
it was an overall thing that was said by Anthony Castillo. So I said it because it was something that was said.
So when you said it as something that was said, you didn't say Anthony Castillo said it, did you, to Mr. Bradley?
When you're in the moment and you're speaking to somebody, I remember that day I was telling him what was said, but it was like a quick thing. Everything was happening so fast. Of course, people do change the words, but yes, it was said by Anthony Castillo, and it wasn't by her.
Okay, I understand. So what also happened when you were leaving that day, when she knew, based upon the plan, when she knew what was happening, she also said, Susan, you're going to be okay. Just relax. Just relax. She said that to you as well, didn't she?
Yes.
Okay. So do you see how that and what she is doing as she believes that they are pulling you out as part of an investigation, can you see how that, what she's saying to you, just, you're going to be okay, just relax, just relax.
Your Honor, I object to him testifying using the words of the defendant.
Right? She testified already.
She did not testify to any of those words. You're the one who testified to those words.
That's what prosecuting.
The question is, can you see how what she's saying?
Well, she's asking her to speak to the mind of the defendant.
I haven't finished the question.
Okay. Overruled, that's the question.
Can you see how her saying that when you're about to go, in their mind, because they believe that you're being called in as part of this investigation to talk, right?
Yes.
And that was on purpose. You didn't tell them that I actually have nothing to worry about. Because I know where I'm going. I'm going to see Brad and to talk to them about what y'all are doing. You never told them that.
No.
But you did tell them you were scared, didn't you?
Yes.
And you weren't scared.
I'm not scared.
You weren't scared when you were going to talk to Brad.
No.
But you told them that you were, so that they would believe your undercover operation.
Yes.
Okay. But they responded to you saying that by, as we just talked about, Michelle saying you're going to be okay, just relax. Right?
Yes.
Okay. And do you see how that is completely different than when you're going to use the well?
Yes.
Than when you testified that on the morning of June 12th, that she walked in and said, you need a lawyer, and then just went to her office? Do you see how what we can actually hear on the recording is her trying to comfort you? And those two things are very different things, right?
Yes.
Okay. we've talked about the wire, and we've stayed on direct examination about it. When you wore a wire on 3 different occasions, is that right?
Yes.
And so you caught a total of, I think somewhere around 17 hours or 20 hours of recording at the precinct.
Correct.
And as the prosecution said, you found no what they call inculpatory information, or no information that would make anybody there guilty or seen guilty.
Correct.
All right. And this is despite the fact that you knew that your job was to try to intentionally provoke conversation about this.
Objection, Your Honor, she has not testified that she was supposed to intentionally provoke. It's
Your Honor.
very argumentative.
Your Honor, I have her exact.
Overruled to argumentative.
This was despite the fact that your job in wearing it, I mean, you're putting a wire in your pocket or a recording device in your pocket to go to work, and then there had been a conversation, and you testified on direct, that what they wanted you to do was to talk about Rodriguez Park to see what comes out of the people's mouths, right?
Correct.
Okay, so when you first, on the day that you first had the wire, I think you called it with Bradley the little thing, like when you would call it, right? You
Yeah.
remember that? Okay. When you first had it, and you were, I guess you were talking to Bradley, an FBI agent,
Yes.
is the FBI agent the one that gave you the device?
Correct. Yes.
Whose idea was it to wear the device?
I don't remember specifically, but it was told for me to, if I were to be able to do it, and I said yes.
And do you know what a confidential human source is?
No.
Okay. So you're not aware that you were classified as a confidential human source by the FBI?
Oh, yes.
Okay. And the confidential human source, you understand, is somebody who has done something wrong, usually. And then
Objection.
Sustained. You can ask her if she knows.
Okay. Do you know that a confidential source is somebody who typically has done something wrong and is trying to do this in order to get out of trouble?
That's a misstatement what a confidential human source is.
Yeah, move along, sustained.
Your Honor, could you instruct the jury to disregard this?
Disregard the last question, jurors.
Well, okay. So you're wearing this device. You don't remember who suggested it. Did you suggest wearing a device?
No.
Okay. So one of them told you and asked you to wear a device, and you said yes.
Yes.
You said, I will.
Yes.
Okay. And while the purpose of wearing the device was to try to get bad information or get information that would make Michelle look guilty, and that purpose wasn't succeeded. But I want to talk about what it meant. What it meant was you put it in your pocket before you went to work, right?
Yes.
All right. And you left it on all day and never turned it off.
Correct.
And that's what actually what Don said in opening statement. So you had coworkers there at your office, right?
Yes.
And these are people that you've worked with for years,
A few years.
a few years. And you spent your workday with them.
Yes.
Right? Okay. So, what you were willing to do, if you weren't in trouble, you were just willing to do it, is you put this recording device in your pocket, and then you talked to your coworkers as if you did not have a recording device in your pocket, right?
Correct.
All right. And they told you personal stuff about their wives, their girlfriends, all of that stuff, normal conversations that you would have with them.
Correct.
All right. And you were able to look them in the eye and have that conversation with these people who had done nothing wrong and know that you were recording them, but make them not know that you were recording them. You were able to do that.
Correct.
You were able to be an undercover, as you said.
Yes.
And so these are people who are telling you their private business, and you are recording them, and you're handing it over to the FBI.
Correct.
And you had no problem doing that.
Correct.
All right. So you could have, if somebody wants to talk about their private business and they're not the target, obviously we know that Michelle was the target, but somebody who's not the target wants to talk about private business, You knowing that you're recording could have excused yourself, right?
Can you repeat that question again?
Somebody who is not the target, a clerk, Michael Villanueva, wants to talk about, he's just talking to you because he thinks he's talking to his friend about something private in his life, or about what he did last weekend, or about what girls he likes, or whatever, or what his wife's doing, or what his kid's doing, whatever. You had the opportunity, the option, knowing that you were recording, to excuse yourself and to not talk about that with him while you had a recorder in your pocket.
Let's see. Well, for the day I couldn't go anywhere, so it had to be on me at all times.
You could go to the bathroom.
Let's see, I don't know. That's all I really could say.
Well, I guess you could change the conversation. You could stop the conversation. You could say, look, I got some work to do. You could have done that. Right?
I just acted like normal
Right.
for the recording, and that's it. And they were looking for the parks. That's all I gotta say.
I understand. But in the meantime, your coworkers who felt like they were talking to a friend were talking to the FBI because you didn't excuse yourself from the conversation and you didn't stop them talking about their personal life. Right?
Correct.
Okay. And you were able to do that, and these are people that have known you for years, you were able to do that and fool them into believing that you were not recording the conversation.
Correct.
You could look these people in the eye, and they had no idea that you were recording them.
But it was on for the parks.
I understand. But the other people that you were talking to, you were able to look them in the eye, and they had no idea that you were recording.
Correct.
All right. So, we've heard that you wanted to move to Seattle, or I guess that you have moved to Seattle. We've heard that.
Yes.
And that's where you are now, at the Seattle City Clerk's office.
Yes.
And let's go back to July of 2019. You had actually been applying for a job in Seattle for a while.
Yeah.
And that was because your husband is a police officer and he wanted to get a job in Seattle.
No, we just wanted to move, just different scenery.
I understand, but at the time that there was a time when you talked to Bradley and you said, this is what I'm doing and this is my plan, and nobody else knows about this but you.
The coworkers knew about it. I mean, and I was very vocal about moving, but I was applying around that time frame.
Well, you don't remember telling him nobody knows outside of this conversation that I'm doing this?
I don't remember.
Okay.
Yeah.
But if he came and testified, that's what you said.
Yeah.
Okay.
That's fine.
And it was recorded on a wire. So we also know what you said because of that, because you're wearing a recording when you're talking.
Okay, that's fine.
Okay. So there was that application process, I just want to understand it. You had started that application process in early 2019?
Yeah, I would say like around January, and I wasn't getting anywhere. It took quite some time.
But at the time,
Yeah.
I understand, but at the time that you're talking to Bradley, I guess in July, maybe into June 26th, you had actually gotten word that you had an interview there, and you were talking to him about the fact that you were interviewing for the position that you have now.
It was a different one for the county, but I did not get that job.
Okay.
Yeah.
So, and thank you for clarifying, because we didn't know which interview we were talking about, but I thought it was for this one. But it was an interview for a job in Seattle.
Yes.
Okay, and it was just, is it King County?
King County.
Okay, so it's King County in Seattle. And And so you knew that you were interviewing there, and we're talking about June 26th. So this is 15 days after the subpoena came on June 11th. Okay? So you went to that interview, I'm presuming, and you said you didn't get that job.
No.
But you continued to attempt to get a job in Seattle.
Yes.
And eventually you were able to get a job in Seattle.
Correct.
And when did you get confirmation that you had the job?
I would say around like the 21st through the 25th of September of 2019.
Okay, that's when you got confirmation that said you had the job.
Yes.
And the the FBI raid of Precinct 2 that you said that you were present for, that was on September 23rd, 2019.
Okay.
And then the next day you quit and moved to Seattle.
Yes.
Okay. All right, may I have a moment? Yeah, Coach.
Yes.
Number 12?
I'm marking defendants, exhibit number 12. Ms. Tristan, I just wanted to show you this photograph. Do you recognize the photograph as a picture of the lobby of Precinct 2, the place where you work?
Yes.
Okay. And I'm going to have a few questions, but does this photograph fairly and accurately depict what it looked like at the time you were working there, I guess towards the end of your time working?
Yes.
Defense offers defendants exhibit 12.
No objection. I see that.
Yes, sir.
Defense 12, is it ready?
All right, may I publish?
Yes.
Okay. Ms. Tristan, I'm showing you Defendant's Exhibit 12. And I just want to ask some questions. These are just logistic questions. This door here, does that go to the constable's office?
No. It's I would say the left one. That door goes there's like a desk there.
Right here?
Yeah.
Okay.
And then on the other side it would be the like admin and all the rooms. The constable's office will be on the left side. So I would say by the TV.
Okay.
Like that would be the door to go.
This door goes in, and then I guess, does this door, I'm sorry, I'm referring to, we were talking originally about the far right door on the photograph.
Yes.
And then there's a middle door, and then it looks like there's a door on the far left. Is there a door over there?
I don't remember, but I know that the middle door is the door that goes into the whole precinct 2.
Okay, and so I know we're looking at kind of the front side of this, but would your desk be kind of closer to this door or to that door or to that door?
To the last door.
This door?
Yes.
Your desk would be close to this door?
Yes.
So if you came in through this door, so this would be kind of like an employee's entrance, but not an entrance that normal people could enter.
Yeah.
All right. So if you walked through that door and looked, I guess, right to the left, that's where your desk would have been?
When you walk in, it will be on the right side.
Okay, on the right
Yes.
side. So the door would be on your, if you're, well, because your desk is kind of sitting, not necessarily,
I guess when you open the door, it'll be on the right side, but it's kind of it's kind of like away from the door. It's kind of a weird layout, yeah.
sure. Okay,
Apologize, Your Honor, there's a lot of different exhibits I'm trying to find. Okay, Matt, first of all.
Yes.
so this is what I'm going to show you. I don't know if you can see it, but we'll move that up. This is an exhibit S4 dot P2-1 that was entered by the state of Texas. And I guess you recognize this as one of the various security agreements that were being used around the time that we're talking about here.
Yes.
Okay, and so I just want to point out a few things. So on this agreement, you see that the date of the event itself is listed on this agreement. Is that right?
Correct.
And the pavilion that has been reserved, that's also listed on this agreement.
Correct.
And it has questions about what type of event is it and who the point of contact is, right?
Yes.
And will they be consuming alcohol? And they can answer yes or no, right?
Yes.
Has the number of deputies that would be required, right?
Yes.
And it has the start time and the end time of the event.
Yes.
And then it also has the compensation or the security fee that the deputy would get for that amount of time. Do you agree with that?
Correct.
Now I want to show you State's Exhibit 31-2-7. Okay, and this was entered in by the state of Texas, and you recognize this is one of your cash logs.
Correct.
And this says cash log on the top of it.
Yes.
And this one starts 2/18/2018, and that's your, I guess, your writing about that, right?
Yes.
All right. And this would be an example of a cash log that you had kept in the purple folder we've been talking about.
Yes.
And this is the original.
Mm-hmm.
Is that true?
Yes.
And in the original, you always kept these in your possession. You didn't give these to anybody else.
No.
The only thing you might have given to anybody else would be copies, right?
Yes.
And you testified on direct that you were directed by, I guess, Michelle to make 6 copies of all the stuff that was in your folder.
Correct.
So what she was doing was she was making 6 copies of these documents that we have told the jury and they understand that was in that folder.
Yes.
And that was, Chief Castillo didn't tell you to do that, it was Michelle that told you.
Yes.
Okay. So, on this document here, though, let's see if I can kind of compare it. On this document here, this doesn't have the pavilion reserved, does it?
No.
Okay. And it doesn't have the hours of the event.
No.
And it doesn't have the hours that the deputy would have worked the event, right?
Correct.
Because within, if the event date is 2/18 or whatever, as we've heard, like a deputy could work maybe 7 to 1, or a deputy could work maybe 2 to 8. But that's not reflected on this here, is it?
Correct.
But all those things are reflected on this here.
Yes.
Okay. So with these cash logs, you testified on direct that these were your cash logs, and this is what you had, and this was a full and complete version of the cash logs that you had kept, and you kept them with you.
Correct.
Okay. So when we look at 31-2-7, it looks like we have full entries from February of 2018 to May of 2019, or May of 2018, same year, right? Would you agree with that?
Correct.
And then it looks like we have on State's Exhibit 31-2-4, it looks like we have event dates that are going down the side. So at this point, and this is your writing on the date column?
Correct.
Okay. And these, I guess this would be the people who rented the pavilion and then the event date,
Correct.
but not the date that the cash was received or collected.
Correct.
Okay. And then this one you said was written by somebody, but you don't know who it was written by, except there's a few.
Mr. Dawson, could you identify what this one is?
Yes, I'm sorry, no. 31-2-8. 31-2-8, what you said was that it was written by somebody, you don't know who, you know it was not Michelle who wrote this other stuff.
No.
Right? No, it was not Michelle.
No, it was not.
Okay. You had some at the bottom here talked about, and you said that you just stopped because it was too much.
Yes.
But we just look at the dates. We're back to, we have dates again, and that's would go from like 2/15/2019 to, it looks like the last date we have maybe is, you have a received date at the bottom here of 4/25/2019, right?
Correct.
All right. And then we have 31-2-5, and that, this document would be in your handwriting, right?
Correct.
And then we have the event dates again here on the second line from the last line. We have the event date. On the second line from the top line, it looks like that's a date that you received cash because it says given to V. Pena.
Correct.
And then that would be a date that you received cash as well. It says given to Constable.
Correct.
Okay. And then on 31-2-6, this also is a cash log. You would agree?
Yes.
And this is almost entirely in your writing. This exhibit is almost entirely in your writing from what I can tell. Is that?
Correct.
All right. And in this one, it has when the cash was received in the date column, when the cash was received, as well as, in most of them, as well as when the event date was. So now it has both of those things on it.
Correct.
So you'd agree that on these different logs as you were keeping them, you were putting different information in the date column depending on the cash log.
It was changing due to Constable. She wanted it differently. So that's why there's always like the pavilion or no name. I don't want no name. So when she didn't want no name, it was blank. So it's just, I did it out of instruction.
Okay. I understand what you're saying, but
Yes.
just what we have gone through, I didn't ask the why, I just said that they are different at different times.
Correct.
Okay. And they were kind of recording different information.
Correct.
And these are, and I can check this with the state. So, and I was just checking because I just want to make sure these are the set of cash logs that you had, and these are the full and complete set, right?
Correct. I believe there should be more.
You're talking about the ones in her writing.
Right. That's thank you. I'm talking about the ones in your writing, the ones that you kept and you logged and you did.
Yes.
This
Okay.
would be the full and complete set of those, right? Okay, sure.
There's more.
You might have to get the purple binder to be sure. But
Yeah, can I
Sure.
get that?
And mind if I approach all of the others and just to be sure?
Thank you.
And just for the record, this purple binder was marked 31-2. It has documents that have not been introduced into evidence by the state. But if you could look through it and see if there's any other cash marks.
It looks like that.
Okay.
These look like surveys.
Right. So like various surveys and other
Yes.
things that have not been introduced. Okay. So Don, I'm just going to reseal.
Okay.
So us and the jury, Ms. Tristan, we would be safe in saying that and we're just talking about the handwritten.
Yeah.
I know that there was an Excel entered and some other things, but the handwritten by you would be safe to say that these are the ones and these represent all the ones that you had in your possession.
I don't know. There's probably more, maybe because I know that the auditors came every 3 months, so they got copies.
Right.
So that would be a best bet to get more information on that.
Well, but if the auditors came, you wouldn't give them your original, you'd make a copy for them.
Yes.
Right. All right, we'll pass it.
I just want to go over just a few things. So when Mr. Goss asked you about how Ranger Freeman met with you and you made a plan, did he coach you and tell you, ask this question, ask that question?
No, it was mostly just regarding anything related to Bexar County parks.
So just start a conversation?
Yes.
So he also asked you some questions about you recording your coworkers. Did you think this was important?
Yes.
And did you want to try to cooperate with the investigation?
Yes.
I'm going to hand you what's marked as State's Exhibit 46-2-1, previously admitted. It's a 4-page document. It's your Excel receipt log. Do you recognize that?
Yes.
So was this included in your purple binder of what you kept?
Yes.
And it was included in the things you copied?
Yes.
And I'm going to hand you what's marked at State's Exhibit 31-2-9, 31-2-10, and 31-2-11. All three of these pages are double-sided. You recognize those logs?
Yes.
And these are the handwritten logs in the writing of the defendant?
Yes.
And at what point in time did these logs come into your possession and you place them into the purple binder and make copies?
After Constable got served and we needed to get some items, and that was added to the piles.
Okay. And afterwards, you just kept them in your purple binder?
Correct.
So I'm handing you what's marked as State's Exhibit 8, and it's already in evidence. You recognize that?
Yes.
And what is this a picture of?
The outside of the office of Precinct 2.
I'm going to place it on the monitor. And previously, you described that there were, this left window is one of the customer windows.
Yes.
This window is just to the right of the administration door.
Correct.
And there's something taped on the window.
Yes.
And what was taped on the window?
There was a document taped, signed by deputies that.
We'll just object those documents, we're not going to introduce them in evidence. So that would be reading the document from a picture in evidence, it's not in evidence. But you can't see that from the.
So I'm going to hand you what's marked as State's Exhibit 9. Without reading what's in there, are those the documents you're talking about?
Correct.
And you had previously testified they were up there a long time?
Yes.
Do you recall what you said about how long?
I would say when the Easter incident started, and it was there for a very long time.
Thereafter?
Yes.
The state would move to admit State's Exhibit 9. We're entering it for the purpose of not for the truth of the matter asserted, but for the fact that these two documents were taped to the window.
Your Honor, our previous objection was hearsay to the document. It's hearsay.
Your Honor, this is the defendant's statement in each of these documents. We're not proving it for the truth of the matter asserted of the content that's in here, just that she made this statement. She had it placed upon the window.
These are pictures and documents. We've already objected to hearsay.
Ladies and gentlemen of the jury, I'm going to give you your first morning break. You're under the same instructions. We're going to take the call back to 10.
All right, for the jury.
Yeah, mine went off like a long time ago. It was back when he was, yeah, do you want to? Like what, your court? Yeah, because it stopped back when Jason was cross-examining her. Is that when it stopped for you? So this says, yeah, that was it. That was the last thing I captured. Okay, so redo it and tell me. I'll get off completely.
I don't know, after this. I already got out. All right, so State, tell me how it's not hearsay, how the contents are not hearsay.
First of all, this is.
Oscar, you keep doing that. I'm not gonna, throughout the whole trial you've been doing that. I haven't said anything. It not only does it not give us a clear record, but it's very disruptive, so please don't do that.
First of all, describing what's in this photograph, states Exhibit 9, there are 2 documents taped to that window. The documents have already been previously identified by the 2 deputies that signed them and the date. Tony Cardona testified to his signature on this document as well as the date. Vanessa Pena testified to her signature on this document as well as the date. And then this witness has testified verifying that the constable's signature is placed on the bottom. The document in its description is written by the constable because it is talking about how she paid for security that day on April 21st of 2019. She lays out who worked and what they got paid. So based on these documents, we can tell that the content is her representation of what had occurred on that day. However, it is in contradiction with the evidence. So we do not believe these documents are truthful. Therefore, we're putting it into evidence to demonstrate that it is not for the truth of the matter asserted that the individuals were paid these funds, but that she placed this on a window for the public to see so that everyone would believe that this is what had occurred. So it is not for the truth of the matter asserted.
Well, why don't you redact the portion that you believe she wrote, because that would be hearsay. That would also be a violation of her Fifth Amendment right. But you can leave everything else that has been proved up, what the 2 deputies said, they validated the signature, even the constable's signature, but the other part is hearsay.
So, can you just give me a minute to read the whole paragraph?
Yes.
So what is laid out on this document, and I believe was already in evidence, you'll have to correct me if I'm wrong, was who worked that day and the times they worked, and then it also has the links. So apart from the top paragraph, I believe all the rest, you may be saying that can be not redacted.
I believe the top paragraph is,
If we redact the top paragraph and then leave the rest, we agree to that.
I'm going to need something to, because marker doesn't always,
I have a shirt.
I'm afraid you might still be able to see it behind.
Although I don't think we could redact that exhibit. You would have to prove it up as a different exhibit, redact it, put a different exhibit number. Both of them go up on appeal, but the jury
I see.
only gets the redacted version because that's already
Marked.
been marked and talked about, right?
Okay.
If I may make a suggestion, I'm assuming, and if I'm assuming wrong, you can tell me, that she doesn't have any knowledge of it, that she's just saying this is what was on the window.
Sure, she doesn't know what was paid and what wasn't paid. She just saw it every day for a couple of months.
So if they produce a redacted copy later, we won't object to the admission even if they finish with her. That's
Yeah, she's not going to talk about anything on here. I just had her identify the signature. It's just at this time I wanted to introduce it.
Then that's.
So we'll work on this.
Yeah,
Okay,
once the
here we
redacted
go.
comes in, then I'm not going to say, oh, you don't have her on the standard. Yeah, we've established that part. We've agreed to that, and then we'll agree to the omission.
Okay.
All right.
Then we're going to be in recess for 15 minutes. start the conversation with you. It's your motion. And I want to focus on your request to go into violations of the Texas Occupations Code. The indictment in this case, so I guess the first question is it a crime to violate the Occupations Code?
Yes, it's a Class A misdemeanor.
What is it?
It's a violation of the Private Security Act. So instead of having that one-on-one relationship when setting up a security agreement,
I know the substance of what you're talking about. I'm asking if it's a crime. So it's a crime.
it is a Class A misdemeanor, yes.
That at this point you could not charge.
Because it is outside the statute.
Sure, it's outside, yeah.
It's not absolutely outside the statute of limitations. Okay, so at the time that, what it sounds like to me, because of the timing of your notice that you gave it to defense the Friday before the start of jury selection, it tells me that's not something you had previously noticed them on.
We had, when we described what the witness's testimony would be, also it was our belief and it is our understanding that this information is contextual to the charged case.
Well, I'm still in relevance. I'm gonna stay with relevance and not move on until I'm satisfied that we can overcome relevance, okay? Because this is more of a bad act, right? You want to go into it as a prior bad act.
Not necessarily, it's more contextual. It gives her her intent for why she's concealing.
Well, the only
records.
reason you can talk about motive is if it's a prior bad act you want me to say is admissible,
It
right?
goes to her intent.
Because no, we're going to go back to the indictment.
Okay.
So please stay with me. Who's going to argue this?
He's going to argue, but I just wanted to tell you, you asked a question about what we knew when we indicted it. I'm the one who indicted the case, and I knew she had violated the Securities Act. In an evaluation of all of the offenses we were indicting at the time, we don't always charge for everything, and those were more misdemeanors. I went with the most serious offenses, which were the tampering case, which is a third-degree felony, the aggravated perjury, which is a third-degree felony, and the 3 official oppressions related to the treatment of Chris de la Cerda, Leo Moreno, and then the arrest of Leo Moreno. Decided not to load her up on a bunch more misdemeanors. I was very aware that there were more offenses I could charge. That was a decision I made for charging, not for a lack of knowledge.
Well, I understand, but was the grand jury summons that you all tendered to her, specifically did it say, we believe you have committed the Class A misdemeanor of operating, violating the private security?
So the way the investigation proceeded was we were looking into the April incident. We were not aware of who was working or who was not working. We did not know the Rodriguez Park procedures. So the first grand jury subpoena was issued, the June 11th one.
Right, but when you, in your indictment, there's 2 intents you're going to have to prove, right? Intent, the act itself, the act intentionally, knowingly, altered, concealed, destroyed. That's one part. The second part of the intent to impair its availability as evidence in the investigation or official proceeding. So if a grand jury is investigating a crime, what crime did you tell her you were investigating? Or who's going to come and testify that you were investigating the crime of Class A misdemeanor violating the Private Security Act?
It didn't come to light until after we learned the documents were not provided to us. We started wondering why. And that's
So does the summons say that? And I understand that the tampering is as a result of her response to the summons, right?
right. Well, so at the time we were investigating Rodriguez Park, there were several offenses related to the Rodriguez Park investigation that we were looking into. We were looking into theft. We were looking into official oppression. I'll have to see the referral because, as you well know, there are 3 investigations going. There's 3 aspects of this single investigation into the precinct and this defendant. So it gets complicated. We were looking into 3 different things. And so specifically related to Rodriguez Park, we were looking into the theft. We were looking into the official oppression, as we did not know whether or not she, at the time, could or could not require Mr. Reyes to pay. as I stated, we did not know the procedures.
So is it the regular course of business for grand juries to investigate Class A misdemeanors?
Well, the thing is, we did not know the value of the money at the time, so it could very well have been a felony. Additionally, official oppression is district court jurisdiction, so they have, so both of those combined would require a grand jury investigation. Until you know, in the end, after your investigation, what you have, you don't know if it's a misdemeanor or felony. And yes, grand juries can investigate misdemeanors. So as we were proceeding, then when we were informed that documents were withheld, we did not know whether it was a mistake or if there was some indication of a cover-up. So we had to evaluate those documents to determine why somebody would not provide them. And as Ranger Freeman and I were going through it, we were like, well, it depends. If you look at this, we're starting to learn who was working out there at the Rodriguez Park. So we were thinking, well, they're utilizing reserves. We know the Securities Act, especially Ranger Freeman being a peace officer, and in my division, we actually prosecute those offenses. And so it's like, well, if she was using reserve, that's improper. So let's, in abundance of caution, reissue a second grand jury subpoena just to make sure that she hasn't mistakenly removed documents and she doesn't subsequently provide them to us, because those documents actually have the names of officers, and then we could go to those officers.
And I understand all that, so I want to know how it's relevant that in the indictment you allege that she altered, destroyed, or concealed Rodriguez Park handwritten cash logs. How is the specific motive that you're trying to get into relevant? If she's violating another, and it's basically another crime.
Right.
How is that not prejudicial? It's in the same line as whatever else is in the other indictments.
Just because it's prejudicial doesn't mean it isn't relevant and admissible. She did not.
Prejudice is actually where it ends. If it's
Well,
more prejudicial and probative,
There
that's
you
where
go.
it ends.
And so it's probative in the sense that the reason why she tampered and fabricated with documents is because she did not want us to know who worked out there, because who worked out there were reserve officers who were not allowed to work out there. And those
So then
officers,
why didn't you, when you have the two reserve officers, ask them why they took cash? Why did you take the cash illegally? If the act, what you're saying, the act of her getting cash to being the middleman for the cash is the violation of the occupations code, and
those
they're doing that
officers
too.
were full-time, they were not reserves. I have reserve officers that are about to take the stand, and they will testify that when they work, they were not paid.
Your Honor, may I address that, just that aspect of it?
I'm still on relevance, yes, go ahead.
But just from our perspective of what presented, I will say that the two officers she has out there have been no statements ever that they made to law enforcement. We have never been provided, we don't have any like memos or statements in discovery as to what they have been testified to, which goes back to our late notice complaint, because it's not only late notice, but the people they're trying to use to prove it have never provided a statement or throughout the.
You've never pre-trialed them?
I pre-trialed my witnesses. I interviewed,
But where are your notes of the pre-trial to them?
I already went over my notes with Patrick Valentine on numerous occasions for every single witness I interviewed.
Where are they?
Well, Patrick said that Don had spoken to him about dozens and dozens and dozens of witnesses, but he doesn't have any recollection that she said we're using this to prove this, to prove this, to prove this, and it was all oral. And
He
so
was
now-
typing notes.
And so now, we're in the position that we don't have those. And so we're in a position that we've never seen or know what they're testifying. We didn't get any memo from the prosecution that says this is what they did, because nobody interviewed them and they never wrote a statement and they never did anything as part of this investigation. And
That
so
is
for
not
us, that's also a surprise.
That is not surprising. They have the witness list, all of the names. I sat down with one of their trial team. I told them, ask me anything, and I'm going to go over each witness I have interviewed, and I'm going to tell you what they're going to testify to. And I did this. That is not mandated by law. I did that as a courtesy. And then I sat down with him.
3914 requires that upon request from the defense, you provide statements.
Those are my work product notes. They never did a statement. Your Honor, I am not obligated under the law. My
I
child.
disagree. If they made a statement
But
to
I
you,
provided that information to them. Whether it be oral and he was taking notes, or me do it in writing, it's not required in writing. And for
Okay,
me to
well,
turn over my work product notes
let's
is
get Patrick
absolutely
here.
prohibited.
let's get Patrick here. I need to know what happened.
I'll call him.
We're going to be in recess till Patrick gets here. Yeah. He's not a witness. Oh, wait. Mark Garcia is listed as a witness. Yeah, he's listed as a witness. The rule has been invoked. The jury's not here.
At that time, the constable was operating a security company in violation of the occupations code. Oscar, can you tell me what provision makes it a class A misdemeanor? Where do you find it in the penal code?
Yes.
It's not in the penal code.
It's in the occupation code. Let me find it real quick.
Okay, we can get that. So as we were discussing that issue, the defense brought up the fact, let's see, that specifically what witnesses are you talking about, Jason, that you have not received their statement?
The witnesses are Deputy O'Neill and Deputy Murad.
Is there any other deputy you're going to call, state, besides O'Neill and Gabriel Murad
Sir, 1 minute.
for that purpose?
Not at this, at the case in chief, Your Honor.
All right, so what I gather is that you don't have any written statements from those two deputies, but apparently they were pre-tried.
Was operating a security company in violation of the occupations code. Also, can you tell me what provision makes it a class A misdemeanor? Where do you find it in code?
Patrick, we're hearing an echo on our end, Patrick, so do you have any other device logged on to Zoom? Because if you do, you have to get off of that device. There's only, just have one on. So there was an echo, Patrick, and it was coming from your screen. So if your phone is on Zoom also, you gotta get it off and just stay on one. Can you go ahead and unmute yourself and see if that's still the case? I'm not muted.
Okay.
I don't think you can hear. Patrick, can you hear me? You're muted.
Yeah. So, what I gather is that you don't have any written statements from those.
Do you hear that echo?
Apparently they were pre-tried.
It's your computer.
That was my fault, Judge. I had the live stream on and it started up. It's on.
Thank you. Thank you for tuning in. All right, so let's back to where we were. The defense says they don't have any written statements. The state has said they told Patrick. So Patrick, I need you as an officer of the court to tell me if Dawn went down the list of witnesses with you and told you exactly what she was going to call each witness for. And I'm really focusing on Gabriel Murad and Marco and Kelvin O'Neill.
So a little bit of background on how we on how that process occurred. Dawn and I would meet. I don't remember how many times. It was at least 3, maybe 4 times. And she would, as part of those meetings, go through her notes on the interviews she had done with the witnesses that she intended to call. These were really dozens of witnesses, and I think it's important to note that they were witnesses related to all of the allegations contained in the first indictment, alleging, I think it was 6 counts. And because she still intended to put that evidence on in punishment even after the case was severed, she would continue to go through a lot of those witnesses. That made it a little confusing. I tried to keep up. Dawn was, first of all, I want to be clear, Dawn did not do anything wrong. She was not trying to hide anything from my perspective. I really don't believe that's the case. But what made the whole situation very confusing was just the volume and the nature of the things being presented. Dawn would tell me about what I guess you could call extraneous conduct. that was related to the tampering case, that was unrelated to the tampering case, because I guess it was potentially admissible or may be admissible at a potential punishment phase. But these were many items, basically every bad thing that any of her witnesses said about Constable Vela, she would relate to me. With regards to the O'Neill and Murad, she did go through her interviews with those witnesses. What my understanding was, and I asked her directly at one point, what's your theory of motive? Because she gave me all of her bank records. I went through all of her bank records. I don't see where she's putting any money in there. Is your theories that she was stealing money or diverting funds or something like that? And Don says, no, we believe she was trying to, we believe she tampered with the records because she was trying to cover the fact that she was using reserve deputies. Now, at that time we had a discussion about the proper use of reserve deputies and how reserve deputies could only be used for basically working traffic control. They couldn't be used in most cases for any other work. And so my understanding of what she was relating was that Constable Vela her motive for tampering with this evidence was to cover up the fact that she was using reserve deputies improperly. Now, she did make reference to the occupation code, but I don't remember, and my notes don't show that anything regarding the Private Security Act. As Your Honor knows, the occupation code basically encompasses everything that applies to law enforcement officers in their occupations, but it's a different chapter, of course. And so she said she would send me those statutes. I don't believe I ever received them, but I have been going through my email in the last few minutes trying to determine whether Dawn actually forwarded me the statute she was talking about. But it was my understanding not that she was referring to some Private Security Act violation, but that she was actually talking about the proper and improper use of reserve deputies.
Okay, so assuming that you get over the 3914 issue, how is the proper use of the reserve deputies connected to Rodriguez Park records?
So, one of the reasons the defendant would not want us to see the cash logs is because it lists names of people who work there. And if we receive it in our grand jury response, we could further investigate to find out who worked out at the park and interview them and determine whether they're reserve or whether they're full-time, or what is going on with the use of employees at the park, so we can see how many violations may have occurred with the Securities Act, which is her motive for not giving us the documents and also for creating them and tampering with them at a later time. So as you noted, in one of
But
these...
don't you already have in evidence the cash logs that Susan Tristan provided?
We do.
And are those deputies listed there?
There are some deputies listed on it. Also, we have an evidence where I walked through the one sample of the security agreement that had O'Neill's name signed
Yes.
in the margin.
Yes, I know that.
His first year, he was a reserve, and he was working out there, and he did not receive payment. Being a reserve doesn't receive payment. However, we know from all indications that when a customer comes in to pay for the pavilion, they pay in full. Security is provided. However, the money cannot go to the reserve. So where does the money go? It was the reason for the theft investigation. And so we have a twofold, and also that very document I showed about O'Neill, her handwritten log for the very same transaction on the security agreement put Pena's name in there, who is a full-time, instead of utilizing O'Neill's name, which was listed on the security agreement, which is how she did her assignments. So her log actually substituted a full-time person in place of the reserve that was listed on the security agreement.
Okay.
Well,
Response?
if I can respond to that first, just because she referenced it, I'd like to see So the document we're talking about is 31-2-13, I believe.
Yes.
Okay. And that's the document that we're talking about, 31-2-13. And I just, for mine, because like I said, we don't have any information on O'Neill. Was O'Neill a reserve deputy on 5/25/2019?
We'll have to ask him. I know his first year in office, he was a reserve, so.
Well, because here's my point, if he wasn't a reserve deputy at this time, and that's one of the things we don't know, then this is not evidence of using a reserve deputy if he's not.
Right, well, I'm not saying that they can call it anything. If you want to inquire of O'Neill whether or not he was a reserve deputy and whether or not he was paid and whether, all of that is fine. What you cannot call it is a violation or a crime or anything like that, because you did question the witness about O'Neill and Pena, and I saw them on the witness list. I didn't know where you were going with that, but that's already in. And so if there is an explanation for why there was a different name in some other law, I mean, that's not my problem, right? That's what you guys are the attorneys. But can she ask O'Neill if he was a deputy reserve? Absolutely. If he got paid, yes. But O'Neill is not going to get asked if that was and neither is Murad, if that was a violation of anything.
Well, we do have another witness that will, who's on the witness list today from DPS to talk about the law.
Okay, and I'll decide if that comes in when we get there. Let's get through these two first.
Well, Your Honor, I would ask, and I would go back to say that, based upon what Mr. Valentine said, this goes back to the notice issue.
Well, hang on. If you guys were not satisfied with how Dawn was complying with 3914, that should have been objected to way back when, before we even picked this jury. If Patrick was being bombarded with voluminous, hey, this witness is going to say this bad act and this bad act, I'm sorry, we are not going to delay this any further.
I understand.
You had notice that they were coming, you had some sort of notice of the substance that they were going to testify to, and you can still cross-examine them. So
I understand, but if I could please just put on the record that the 404B notice we were given the Friday before trial does not list these witnesses, does not list how these witnesses are going to be used in this manner. The way that Mr. Valentine just talked about it.
nobody is talking about the violations of the Security Act.
So
At
nobody
this
will talk
point,
about.
nobody's talking about that.
And so nobody will talk about using reserve deputies for security as a violation of that act.
No, they could talk about using a reserve deputy and in what capacity and whether they were paid. As to the ultimate issue of whether or not that was a violation of the law, these two witnesses are not getting into that. That's not allowed.
That is not why we would call
Okay,
him.
so call them. Let's keep it.
And Your Honor, may I further state just for the record that on the face of Article 39.14 on discovery, it absolutely excludes, and I'll quote, "but not including the work product of counsel for the state in the case and their investigators and their notes or reports." It is absolutely an exclusion to production.
I am not saying to give your work product over or your notes. I am saying you should have written them a memo. I met with O'Neill. He will testify to this.
It did one better by meeting with counsel.
I know, but about
Not one better for us.
60 plus witnesses. So
Well,
again, their complaint about that to me is not going to be an error in this trial.
And
So,
Your Honor, you asked whether Class A misdemeanor is referenced in the occupation code. It's section 1702.386 of unauthorized employment, and it's listed as a Class A misdemeanor.
okay.
And Your Honor, there's another issue of these two witnesses and what they'd be available to testify to, and it has to do with the shredding. On cross, we believe that Mr. Goss has opened the door to discussing the policies and procedures that were in place at the time, and that they were strictly held by their client. However, on his cross of Michael Villanueva, he asked a question, and Mr. Villanueva responded by saying, subsequent to his admonishment for getting in trouble for shredding, he was directed to shred a box of documents by the defendant. Well, I believe that opened the door to the following two witnesses to testify to the very last day she was in office. She required 3 officers to stay late that evening. I believe one said till 11 p.m. And they were required to shred documents, many files. That the defendant was the one who directed them to shred the documents.
I don't think that's relevant to guilt innocence, and absolutely for punishment and not guilt innocence, because nobody talked about the shredding in the context of not making documents available for an investigation or grand jury proceeding. That was not the context that it was asked in. So unless that comes up again, if you guys want to approach again, that they cannot go into shredding, especially. That could be for any reason. Donna K. McKinney took office and cleared everyone's computer. I mean, she's not under indictment, right? Like,
Maybe
we're not.
should have.
That's just what I heard. I don't know that. So don't call me as a witness because I don't know. I took office after that.
In your honor, just so that the record is clear, our objection is based on insufficient notice and notice on the Friday before, and the Friday before notice did not include these witnesses in context to what they were going to use to try to prove them. And that we're basing our objection on that. My understanding is the court is overruling our objection as to that, and it will allow the witnesses to testify.
Okay. Well, I understand your objections. They're still overruled. So.
Yes, Your Honor.
So, Your Honor, just so you know, based on your ruling just now, I think maybe it's only going to be O'Neill that testifies, but I'll have to review this to be sure.
Okay, call O'Neill. But let's get Susan on. Let's finish her off. And what my last comment was simply meant to say that administrations change and people get rid of stuff on their computer, not that anyone's creating crimes.
Yes, Your Honor.
You can minimize it. Patrick, you can stay on if you want, or you can call it off. It's up to you. I'm finished inquiring.
Thank you.
Thank you. Everyone go ahead and be seated. I believe we were still on redirect from the state.
State passes the witness.
Your Honor, we have no further questions.
May this witness be excused.
Yes, Your Honor.
Thank you, Ms. Tristan. You may step down. Ms. Tristan, hang on. You still remain under the same rule, the same standing order? Okay, thank you. Call your next witness, please.
State calls Kelvin O'Neill. Your Honor, may we approach?
Yes. You could please raise your right hand.
Yes, ma'am.
Do you solemnly swear or affirm the testimony that you're about to give in this call shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Mr. O'Neill, I did issue a standing order in this case. Are you familiar with it?
Yes, ma'am.
You understand your responsibilities in being a witness in this case?
Yes, ma'am.
Okay, thank you. State, you may proceed.
Could you please state your name for the record?
Kelvin O'Neill,
Could you spell your last name?
O'Neil.
And what rank are you?
I'm a deputy constable.
Are you still with Precinct 2?
Yes, ma'am.
When did you first become a peace officer?
2017.
And what was your first job as a peace officer?
Here, Bexar County Precinct 2.
Do you recall when in 2017 that might have been?
Say again, ma'am?
Do you recall when in 2017 you may have begun at Precinct 2?
I started in Precinct 2 back in 18.
Oh, in 18, I'm sorry.
Yes, ma'am.
You became a peace officer in 2017,
Yes, ma'am.
but that was your first job.
Yes, ma'am.
So Mr. O'Neill, see if you lean really close.
So, has working at Precinct 2 been your only job as a I guess carrying a commission as a peace officer?
Yes, ma'am.
And did the defendant Michelle Barrientes hire you?
Yes, ma'am.
Do you remember in 2018 when it was you were hired?
I don't remember the exact date.
Okay. Was it later in the year or earlier or mid?
I want to say it was mid.
Mid, okay. And when you came on to work in 2018 for Precinct 2, were you a reserve or a full-time?
Reserve.
Do you recall how many hours a month you had to give towards the precinct official duties?
I would say it was at the time 16.
16? Did that change over time?
Yes.
Do you recall what it changed to?
No, ma'am.
When you were first as a reserve officer at Precinct 2, what were your duties?
We were assigned to help with civil. We would work the courtroom and lobby security.
And when you refer to with civil, what does that mean?
Helping the full-time deputies execute civil paperwork.
And you remained a reserve for how long?
I want to say close to a year.
So that would put you as a reserve from roughly mid-year 2018 to mid-year 2019?
Somewhere around there, yes, ma'am.
And at that time, then you became a full-time?
Yes, ma'am.
When you were a reserve, did you ever work Rodriguez Park?
Yes, ma'am.
And when you worked Rodriguez Park, what did you do there?
Provide security
And provide security where?
for the pavilions.
When you worked security for the pavilions, did you do this ever alone?
A couple occasions, yes, ma'am.
And then on the other occasions, what did you do?
There was another deputy there with me.
Do you recall, and I know it's a long time ago, and you might not remember how many times, but do you recall how many times you worked Rodriguez Park while you were reserved?
I don't know the precise number.
Can you give a ballpark?
I would say probably about anywhere between 8 and 10.
8 and 10 times?
Mm-hmm.
During that time, were you ever paid?
No, ma'am.
And then after you became a full-time at Rodriguez Park, Precinct 2, did you continue to work at Rodriguez Park Security?
Yes, ma'am.
And as a full-time, do you recall how often you would work Rodriguez Park?
Whenever they needed me to. Can give you, again, a precise number.
Was there some point in time that you just stopped doing the side job at Rodriguez Park?
When I was no longer needed. I mean, if I didn't get the call to go, I wouldn't go.
And, okay. So when you work security, what do you do?
So you're there providing security for the pavilions and for the people, and if there's alcohol present.
And providing security, do you stand in a certain place, or how do you position yourself?
You would either stand out front, let the people know you're there, or park your vehicle up front. That way you could watch the party or festivities, whatever was going on.
So you would, your vehicle would be in the parking lot, but near that pavilion you're assigned to?
Yes, ma'am.
When you were a full-time officer working Rodriguez Park, were you paid?
Yes, ma'am.
Do you recall what the hourly rate might have been?
I don't remember the hourly rate.
Do you recall who would pay you?
We would get paid through the office, through the constable.
And you say through the constable, who physically handed you the money?
The constable would give us the money.
How did you know that you were going to be assigned to security? Was it voluntary, or did you get an assignment?
They would usually ask us, who would want to volunteer for work. I mean, you're getting paid for it, so sure we would take the gig for the extra money.
So as a full-time, kind of word would go out and say, hey, who wants to work?
Pretty much, yes, ma'am.
And then from those individuals, who would decide who worked?
The ultimate decision would be the constable.
And when you were reserve, was it the same process? Did you volunteer to work?
I was usually asked to work, so if they called me, I would show up.
And so, however, you would not be paid. So, how did that process work? I mean, you still just agreed to do the work?
It was told that it would count towards our hours of service.
The 16 hours a month that you were owing the office for carrying your commission?
Yes, ma'am.
Do you know if that indeed was put into place?
I really don't know.
Pass the witness.
Deputy O'Neill, my name is Jason Goss. I represent Michelle, and I have a few questions for you. And I'll start with I guess you were there when the FBI raided Precinct 2?
Yes, sir.
And what I mean by there is you were employed at the office?
Yes, sir.
And were you actually physically present to see it?
Yes, sir.
And were you aware at the time that Ranger Bradley Freeman was one of the investigators on the case?
No, sir.
Okay. Did you ever give a statement to Ranger Freeman about any of this that you testified to?
I really don't really know. It's been a while back.
Sure. Do you ever remember talking to Ranger Freeman at all?
The only time I spoke to Ranger Freeman was during the actual day itself.
Of the
raid.
search. Did he, I'm sorry, you nodded your head, was that yes?
Yes, sir. During the raid, yes, sir.
And I can see, and we can all see that you nodded, but the court report is taken down.
Oh, gotcha.
That's why I clarified. So I guess, well, when you were talking there, as this was going on, did he sit down and interview you and ask you about your experiences working either at the constable's office or Rodriguez Park? Was there an interview that was conducted?
No, sir.
Okay. And you don't remember any other time that you were ever interviewed by Ranger Freeman?
No, sir. The only time I spoke with him was there at the office.
And, Your Honor, may I approach the witness?
Yes.
Deputy O'Neill, I'm showing you what I have marked as Defense Exhibit 13. Do you recognize what Defense Exhibit 13 is?
It looks like my Texas Commission on Law Enforcement's personnel status report.
And what that is just in order to be a licensed peace officer, you have to have what's called a TCOL license, or a Texas Commission on Law Enforcement personnel status report, right?
Yes, sir.
And this, in 13, this is in documents similar to that, or documentation of when somebody is a reserve officer versus when they're full-time.
Yes, sir.
And so I just want to go through and just talk about, as you see that, do you remember when you were reserve and when you stopped being a reserve and became full-time?
It says 6/4/18
To,
11/27/18.
okay, so not June of 2019.
Yes, sir.
And then you started full-time 11/27/18, is that right?
Yes, sir.
Okay, so, and I'm not saying that you were, it was a long time ago.
Yes, sir.
Sure, so, but looking at your official documentation, is you could say, well, I started as a reserve 6/4/2018, and I stopped being a reserve and started being a full-time in November of 2018. Is that right?
Yes, sir.
And Your Honor, I know I said it before, but I just want to just make the court aware that we have discussed this stuff with him without waiving our objections because we had to based upon their direct examination. So I just wouldn't want there to be any issue about waiver on that issue. And with that, we'll pass it.
Raise your right. Yes. So the first person that you talked to about this case and was interviewed was by whom?
I want to say, I guess you.
Yes. Pass the witness.
I don't have anything from you, Judge. I'm sorry, Judge, may I withdraw that just for a second? When you did go to the DA's office to talk about this, did you write down any statement ever about, did she ask you to write down what had happened or what you remember in any kind of written form?
I didn't write down anything.
It was just all verbal that you told her?
Yes, sir.
Okay, that's all I have.
Okay, Deputy O'Neill, thank you for being here. You still remain under the standing order until you're excused from it, okay?
Yes, ma'am.
Thank you, sir. You may sit down. Call your next witness.
State calls Manuel Gonzalez. Whenever you approach, this is when you're
Yes, ma'am.
Your Honor.
Good morning. If you could please raise your right hand. Do you solemnly swear or affirm the testimony that you're about to give in this call shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Have you received a copy of this standing order, or has anyone explained it to you?
I have received.
Okay, so you understand your responsibility with regards to being a witness in this case?
Yes.
Thank you. You may proceed.
Could you please state your name for the record?
Manuel Gonzalez III.
And can you spell your last name?
Gonzalez, Gonzalez.
Mr. Gonzalez, what is your job title
Human Resources Director
for Bexar County?
for Bexar County.
And how long have you been working for Bexar County Human Resources?
8 years.
And how long have you been the director?
3 years.
And based on your duties and responsibilities, what kind of knowledge do you have about county employees? I mean, just generally, like extensive knowledge?
Yes.
So do you need to know all of the policies and procedures as it relates to every single county employee?
Yes.
Are you familiar with the county employees that work at the various precincts?
Yes.
And are you familiar specifically with the county employees that work at the precincts that are peace officers?
Yes.
And based on that knowledge, are full-time officers county employees?
Yes.
Are reserve officers county employees?
No.
And so reserve officers are not paid by the county?
Correct.
Pass the witness.
I have no questions.
Thank you, sir. You may step down and you remain under the same order, okay? Call your next witness.
Your vote, Judge?
Yes. Sorry, my mic is on.
I'm going to break you for lunch yet, unless you're really hungry and you want to go to lunch. But I want to see how long this is going to take, and if I see that it's 12 o'clock and we're still going, I'll give you the break for lunch, okay? But for now, just hang tight in the jury room.
All right, for the jury. Thank you. Be seated.
State, can you tell me what the purpose is of the next witness?
So I anticipate it would be about 20 minutes of direct examination from my part. The purpose would be it goes to what we've been saying, Judge, as far as the intent behind hiding the records, the motivation, that And also on cross-examination, I think it was on Friday, today's Monday, right? On Friday, Mr. Goss attempted to allude or imply that...
Oh, hang on.
He rushed out to the rescue, Jada.
Sorry.
Sorry.
Thanks,
stay
Ed.
back.
I've started without a court reporter before, so. I actually have. Okay, so start with the part that you said on Friday, Jason opened the door.
So on Friday, Judge, and would you prefer I said?
It's up to you. We're informal, right?
Oh, we're informal.
Yeah.
So on Friday, when Mr. Goss was cross-examining Susan Tristan, there was a line of questioning that was presented that maybe the practice of paying the constable's office to arrange security would be considered maybe a more preferable practice as opposed to paying an officer one-on-one that the citizen had to do. The state's argument is open the door to us introducing this evidence that practice was unlawful because it could never have been a preferable practice because that is a violation of the law. So that has left an impression with the jury that, well, maybe the defendant did this practice because it was a more convenient way or a better way for citizens to obtain security. When in fact that's not the case. She should never have been allowed to do that because that's a violation of the occupation code. That's the first reason why.
Okay, let me respond to that.
Yes, Your Honor. Well, even in their own motion, if I'm looking to supplement the state's request to introduce evidence of defendant's motive. The court has heard testimony from Officer Mark Olivares that having customers pay a middleman instead of the officer in a one-on-one transaction is a violation of the Private Security Act and it is unlawful. They actually asked those questions in front of the jury. And so,
I don't think they asked if it was unlawful.
not if it was unlawful, but they asked about
Which is where I cut it off.
Right, like you don't do that. And then they talked about the fact that it was that she was in uniform. She had witnesses testify, Jesus Reyes in particular, that she was in uniform. It was intimidating, and getting money at the scene was viewed as some sort of extortion. And so what they're doing when they have these witnesses testify that, all I was trying to do was clarify this. What this policy change does is, what this did, and they had her talk about the policy change and everything else. And I'm trying to clarify that the concern that Jesus Reyes had about deputies at the scene taking their money, that concern goes away with this policy change. Because that is true. I mean, and I'm not opening the door to the unlawfulness of it. I'm saying if you had complaints, Susan, which is where this came up, if there were complaints that deputies weren't getting paid in the field, or in the instance of Jesus Reyes, who testified that a uniformed deputy with a gun, what they said with a gun on their hip and in full uniform and everything else coming, I was pointing out that this practice eliminates that need or that necessity at the park. which is what they have been presenting as some sort of evidence of bad conduct or scary conduct or intimidating conduct. So it's kind of like, I mean, if they're saying I've opened the door, they're trying to bait it out by saying this is bad to have uniformed deputies at the thing, but then when I say, well, this changed that, so that there's not that bad thing that they're saying it is, now they're going, okay, now you open the door, which they kind of tried to bait in the first place by saying it. So all I was trying to do with my question is not a false impression of the jury. I was trying to clarify that all the jury's heard is that deputies at the scene with uniforms and guns are scary and that's a bad thing to have happen. And I was just trying to say, well, this policy makes it not that. And so some people could say, well, if I don't like deputies collecting money for me at the scene, I'd rather pay at the thing rather than have to deal with all this stuff out here. And that's kind of the difference I was trying to make.
Right, and that's what the testimony has been, that there was, that she collected the money after the Easter incident and before the Easter incident. I mean, I think it was even the parks director who said that, yeah, they refer everyone for security to the constable's office. So, I mean, that's the general,
Right. And
but that's what the jury has heard.
And so we will develop testimony the way it should have gone is, yes, they would be referred to the constable's office, and the constable's office would provide a list of officers that the patron would then need to contact individually in order to be in compliance with the Private Security Act. Also, I just wanted to point out...
Wait, say that again?
So if you're going to set up security in order to be in compliance, the Parks and Rec can refer you to the constable's office. When the patron then calls, the patron is given a list of officers who work security, and it's up to the patron to then call each individual officer to kind of arrange who's going to be the officer that will be doing security in order to be in compliance with the Private Security Act and under the Occupations Code. And so I also wanted to point out, Judge, that what's been admitted into evidence is the fact that the defendant did have knowledge that she was in some way in violation of the Private Security Act with reference to why the second security agreement was changed, and highlights, or I think it's points out words that this constable's office is not a private security firm or private security company. So that is also evidence that in her mind she knows that she's in violation of the Occupations Code. Which again goes back to
trial for that. That's what I hear all of that. I get all of that, but I told you I was going to be very strict with the relevance. So evidence of motive is relevant to prove the indictment, not to prove that she committed some sort of classic misdemeanor.
It's proved her intent about why she needed to conceal these records, why she needed to alter these records. That is why. Because if we don't,
we already talked about the intent in the indictment. It's the actual act, intentionally or knowingly, alters, destroys, conceals. And then the second part of the intent is to impede this investigation into a criminal proceeding.
It also rebuts defensive theories. One defensive theory that's been presented, one that was presented in opening was...
But the case law you gave me on that is different than what we're talking about today. So the case law was the guy with the meth lab that said, I never ever, and then there's evidence that he was busted with a meth lab 7 years before the actual meth arrest. So
in opening, Your Honor,
that was to rebut. Yes, that's what the case law that you gave me said.
Yes, Your Honor. And in opening, Judge, one statement was made by opposing counsel that...
So if it's stated in opening, if he got up and said, we've never operated an illegal security company, you're in. But that's not what happened.
Of course, he didn't say it in those type of words, but did mention...
What did he say?
He said, and we can refer back to the record, but he did say when talking about the transaction, about the customer paying at the constable's office, she did nothing wrong. That is a false impression with the jury. She did do something wrong. She was in violation of the Occupations Code. And she knew it. And that's why she was attempting to hide the records.
Okay, so tell me which evidence has, what witness has said that?
Oh, also, Judge, if I could point out, and
Yes.
I could point out some monitor,
Yeah.
since we're here. Defense Exhibit 10. Oh boy.
10 is Ms. Reyes' law. Did you
Correct.
say defense?
So, yes, this is Defense Exhibit 10. So, we'll point out something very important. Don't read it. individual had, so in reference to Jesus Reyes, individual had over 50 with alcohol, failed to contact office, receipt made in the field for Jesus Reyes Jr. Due to large crowd and alcohol present, the Bexar County Parks and Rec requested for our deputies to be present. First, we know that is not consistent with the evidence. With alcohol and large attendance count. Yet, Mr. Reyes failed to pay, and it appears he lied on the attendance count and alcohol. So why that's relevant, Judge, is because she has to say that he failed to pay, because if she says, oh, he paid me, the actual truth, she then can't take the money and then pay the deputies. So she has to say what? That he failed to pay. Which then also corroborates why she takes those two deputies to the auditor's office in order to get paid from the county. So that's why she can go under the guise that she's not running a security company without a license. Again, that statement in and of itself, Judge, is a lie that's present. We know that it's inconsistent with the evidence.
Well, you can argue that to the jury. I still have not seen where, for you all to call a witness from Austin who doesn't know anything about this case and is just going to explain the law that is not relevant to the indictment. It's the law of violating or operating under the occupations code is not a violation of the law in this indictment that you have alleged.
But it is a violation of the law of the state of Texas, and which gives her the motivation and the intent to conceal those records.
No, you don't get there. So, anything else?
No.
Call your next witness, Dave.
You confer, Judge? No?
Yes. I can also break for lunch. I did tell the jurors that we were still working close to noon. I would break for lunch. Can I just break for lunch for them?
Yeah, Your Honor, because for scheduling purposes, we have 2 more witnesses that are short. And then we have Ranger Freeman on standby, so we'll probably...
Can we do the next 2 short ones? And then break for lunch? And that way Freeman can get here?
On one of the...
And are we talking like 30 minutes short?
No, probably. We have an ADA, Eddie Flores. He's going to talk about the grand jury subpoena, the process, how the grand jury works. And then we have Investigator Scott McNaughton, who was present with me when Les Sakanowitz appeared. However, there is...
He might not be short.
Okay.
Based on what you guys were arguing the other day.
Well, I'm not sure you're going to let him testify, and I say that because I never put him under the rule, because I never intended to call him, because I've never had to prove a chain of custody on a grand jury subpoena. However, he is only going to testify to the limited purpose of the fact that Les Sakanowitz appeared at the office. He came into the investigator's office with me. We met in Scott's office, the investigator. And then he saw Les and I talking about the grand jury subpoena. So it's just for the purpose of establishing the fact that we did have a subsequent meeting in the district attorney's office related to the grand jury subpoenas to just link that chain between my contact with the investigator.
That's appropriate. I know he's not listed, but that's appropriate.
And he said...
You guys raised the chain of custody issue.
Yes, I understand that.
I don't think we can call it a subsequent meeting, though, because I think we can call it a meeting. Because I know Les was a little confusing, but yes, if the investigator remembers and that's what happened, he's allowed to testify.
He can't remember everything we talked about or what we were doing with
Just
paperwork.
the meeting.
The meeting occurred, and that it had to do with grand jury subpoenas to the precinct.
Well, I guess what I'm saying is that at this point, the one thing that was not confusing is that Les took the documents to Dawn.
But there was something else after that Les could not really recall. And
Well,
then that was
and
when
maybe
he had to go retrieve them and then come back and comply or something.
Right, so I guess that's what I'm not clear on just with the proffer right now, but I'd like to get clear on is...
That's what I'm clear on.
It's discussing that meeting that we had subsequent to the issuance of the grand jury subpoena.
And if I can just, I'll just hop on with you guys if I can, just try to figure out, because my understanding is that what Scott would testify to is that when Les came and gave the documents to Dawn, they had a meeting about it.
No,
Okay, that's what I'm not.
no, it's only Les and I met the first time.
Okay.
Then I had to call him back for a subsequent meeting because he had done it wrong. he didn't give us business records affidavit.
Right.
So then
I'm clear on that.
Okay.
That's allowed.
I'm clear on that. But it doesn't have anything to do with him less having to go to Ranger Freeman with the other copy of the documents so that he would go directly to
No, because I do not believe Investigator McNaughton would have that information.
So you said, hey, you gave me these documents, but they don't have a business record affidavit. Here's how to do it right.
Yes.
And that's the whole substance of it. And then,
Well, even Investigator McNaughton can't even tell you that's what I said because he knows that he was there for the purpose of Les taking things, documents on the grand jury subpoena related to Rodriguez Park. He can't even tell you the details of it.
I don't see necessarily that part of it is wrong. I think the hearsay is obviously like, oh, this is what I said, but she's kind of said that he doesn't remember.
He doesn't remember.
But the issue, I think, that she said is that he wasn't under the rule. And so that's a little different because he was on the witness list. So we're not saying that we don't have notices copy him up. But if he wasn't under the rule and he did learn something based upon this, I just think somebody needs to inquire. Because it wouldn't be his
Well, he hasn't
fault.
been present in the courtroom, right?
It's just,
No, I think it's been live streamed all over this office, so
Yes.
people
There's
are
a lot of
listening.
people watching it.
I think he has watched some of it, but he isn't going to, his testimony will have nothing to do with what Les said. All that transpiring of back and forth, he wasn't present for those things except for this
I
one
think it's
time.
fine, even if he saw the live stream, because he's not going to be called for any other fact other than this meeting occurred.
Sure.
And it had to do with whatever he recalls.
Can I just ask, does he have any idea what date this subsequent meeting or this meeting occurred on?
I don't know that he remembers the date. I didn't ask him.
I just want to get those two witnesses on and off quickly. Can we do that by 12:30 so I can set the expectations of the jurors?
I understand.
Can we do that?
I believe so.
Okay, can you talk to the jurors, tell them we have two witnesses, we could do it in 30 minutes, and then we'll break for lunch, if that's okay with them. And if it is, bring them in.
Your Honor, can we just at least have you inquire whether or not he watched Les Hamilton's testimony? Because that would be, I think that would bear directly on it.
I can inquire, I'm not sure that I would exclude him if he did. He was not under the rule because the issue had to develop until we were in trial.
Judge, part of the problem with us is. Quiet, guys, quiet. Way through it about what occurred and what didn't, and talked about Scott being there, not by name. So I think that aspect is a problem for him if he watched well. If you saw Jose Reyes, I don't think he did.
Okay, hang on. Is he here? Can you bring him in so we can ask him if he saw Les's testimony?
I'll have to call him. We were going to bring Eddie on first, but
Okay, let's do Eddie at least, and if we have to take him out for lunch, that's fine too.
Okay.
Let's do Eddie now. Bring him in. Yeah, just bring him in.
Okay, thank you. You may be seated. State, call your next witness.
This is called Eddie Flores, please stand.
Mr. Flores, if you could please raise your right hand. Do you solemnly swear or affirm the testimony that you're about to give in this call shall be the truth, the whole truth, and nothing but the truth, so help you God?
I will.
Have you received a copy of the standing order, or has it been explained to you?
I've received a copy, Judge.
So you understand your responsibility in being a witness in this case?
Yes, Your Honor.
Thank you. You may proceed, State.
Thank you, Judge. Mr. Flores, could you introduce yourself to the jury and spell your last name for the court reporter?
Sure. My name is Eddie Flores, and my last name is Flores.
What do you do for a living?
I'm an assistant district attorney.
How long have you been an assistant district attorney?
Total, I started in November 2011 in Nueces County. That's Corpus Christi, Texas. And then when my wife got a job over here in San Antonio, I was trying to be a good husband, and I followed her. And so I've been an assistant district attorney here ever since.
And do we know each other?
Yes.
How do we know each other?
Colleagues.
And what's your current duties with the Bexar County District Attorney's Office?
Sure. Currently, I am the what's basically known as the grand jury attorney. I supervise and run the daily, doings of the grand jury.
Could you explain to the jury what a grand jury summons is?
Sure. Grand jury summons is a legal document that is part of a grand jury investigation that a prosecutor or the foreperson of a grand jury can sign to execute it, and it can summon witnesses, documents, stuff of that nature as part of a grand jury investigation, looking into a case.
And may I approach the witness, Judge? Showing you what's been marked as State's Exhibit 46-2. The first document, is that a typical grand jury summons?
Yes.
And on grand jury summons, specifically when requesting records, is it a standard practice and procedure to request a business records affidavit with it?
Yes.
And could you tell the jury what a business records affidavit is?
Business records affidavit is the person either served or the custodian of records for the documents that the prosecutor or law enforcement agency wants would fill that out, usually with the person's name and talking about the organization, what's the organization called, and the number of documents that are produced in response to the grand jury subpoena.
And what's an absence of business records affidavit?
An absence, in my experience, has been that there are either no records responsive to that grand jury subpoena, or that the person just forgot to fill it out.
And does an assistant district attorney's signature on a grand jury summons make it effective?
Yes.
And then, are the grand jury proceedings secret?
Yes.
When do the documents or evidence gathered as a result of a grand jury summons become not secret?
To whom?
To the defendant or to the public?
Oh, okay. All right. So there's two sets of rules for prosecutors and for everyone else. For the public, it would be after the matter. As far as documents, it would be after the matter is no longer before the grand jury.
And once an indictment is returned, is the matter no longer before the grand jury?
The law states that after an indictment is returned and the person is either in custody, then it becomes public, or if the case is at large and the person is not in custody, then the clerk's office cannot make the indictment public until that person is in custody.
What about when the person is on bond and the magistrate is at the office?
Yes, it becomes public, yes.
witness, Judge.
Yeah, Mr. Flores.
You can call me Eddie.
Thank you. We also know each other.
Yes.
Because I was also at the DA's office. We came in, I came from another county as well, we came in about the same time.
Yes.
And Nico hired both of us.
Yes.
Now, I think that there may have been some confusion. I just want to straighten it out with I think what you were talking about is the knowledge to the public that the person has been indicted becomes available, right? Is that what you were talking about at the end of your direct examination?
I mean that. No, I mean that is also true. That once an indictment is made public, well then the public knows.
Sure, but I guess the specific question that we had is like those documents that came into the grand jury that the grand jury reviewed. That wouldn't become public, like I guess available to the public upon the indictment of the person.
Oh no.
And that's because there's still, those documents don't just get released just because there's an indictment. Okay, so I wanted to clear that part up. As far as, sometimes in the grand jury, well, first of all, when there's a grand jury, that's just the prosecutor most of the time and the grand jurors and nobody else, right?
Correct.
And the lawyer for the person that's being investigated does not get to go.
No objective relevance.
Well, they're asking about the process. The lawyer for the person being investigated doesn't get to go in and defend that person in the grand jury.
No.
And in fact, common practice is that a prosecutor has a file, he tells the grand jury this is what the file says, and then they vote yes or no on it.
No objective relevance. And discussing matters in the grand jury.
Because they're secret. I'm just talking in general. I mean, that's kind of the, you would agree that's the general practice.
Yes.
So as far as the business record affidavit, well, let me ask you this real quick. Sometimes witnesses do testify and a record is made of their testimony.
Correct.
And as in your experience and as you know, that record, even if the person is indicted, does not become publicly or even available to anybody else outside of the grand jury automatically.
Not automatically.
So there has to be a finding that's made by the court that there's material to the administration of justice, and then the court can release testimony because the grand jury proceedings, as you testified, are secret, right?
For the defense, you have to show that there's a particularized need.
A particularized need. I was trying to think of what that was, and I don't think that's why you're the grand jury attorney. So, yeah, that's right. There's actually a thing in the law that says, even a defendant who is being prosecuted by a DA's office cannot get access to a statement that was made to the grand jury by a witness unless they show a court there's a particularized need and the court says, okay, I'll allow you to have that, right?
Yes.
And that's because the things that happen within the grand jury room, specifically, we're talking generalities, but specifically on a specific case, those things are secret, and that secret is very important to our system.
Correct.
And so, for instance, if you're in the grand jury and you hear something that happens, you can't even go tell your wife what happened.
No.
You couldn't go even tell Oscar what happened, who works in your office, unless he has a reason or a need to know that.
Correct.
And when you talk about business record affidavits, they are asked for generally, just like you said. Everything you said, I agree with. They're asked for generally. Sometimes they're asked for people who don't understand what that is. You agree with that?
A lot of times, yes.
And sometimes they're asked for and they come back and they're not filled out accurately or completely because some things are wrong about them. You would agree with that?
Yes.
Because oftentimes what's happening is that lawyers, which is the prosecutors, are asking for things from non-lawyers who don't know the law or understand kind of the common practices that we as lawyers have. Do you agree with that?
Yes.
And you know that when we talk about just in general in grand jury proceedings, well, let me ask you this, because I know this. You're a grand jury prosecutor now, but that's not all you've done. You've been a trial court prosecutor, right?
Yes,
You've done the same job that Oscar's done.
yes,
And so you understand that with the grand jury, the burden of proof to get through a grand jury is probable cause, which is one of the lowest burdens, right?
correct, yes.
But the burden of proof at a trial and the burden of proof that the jury has is beyond reasonable doubt.
That is correct,
And that
yes.
is the highest burden in our system.
Yes,
I'll pass it.
So you testified that live testimony within the grand jury inside the room is secret.
yes.
What about once someone is indicted, can the records obtained from the grand jury summons be introduced at that trial?
At the trial, yes.
I see both attorneys up here. Please.
May I proceed, Judge?
Yes, sir.
Thank you. Mr. Flores, once a prosecutor or an investigator on a case receives those documents from a grand jury summons, can they show, either the prosecutor or the investigator, show a witness or a victim those records in order to get their interpretation of them?
A witness in the case?
Or a victim in the case, yes. To get their interpretation. Or an expert.
You're talking about after indictment? Or before indictment?
During the investigation.
Before the indictment.
Before the indictment, yes.
Just so I'm clear, can you repeat the question?
So can a investigator or a prosecutor, after receiving documents that were obtained as a result of a grand jury summons, take those documents in preparation of their criminal case and show them to a witness or a victim on the case in order for the prosecutor or the investigator to get their interpretation of what those records show and establish, and in order to understand that?
To assist the prosecutor, yes. If you're saying to assist the prosecutor,
Yes.
yes.
And to assist the investigator?
Yeah, which is ultimately assisting the prosecutor, yes.
Absolutely, Mr.
Anything else? Good to see you.
Thank you. You may step down. You remain under the same rule.
Thank you, Judge.
Clear with the next witness, please.
We call Investigator Scott McNaughton.
Your Honor, I'll remind the court that an inquiry is my turn to ask this witness.
Yes, I will ask him. Oscar, can you ask him before he walks in what the answer to the defense?
I told them to get Brad here to testify.
Give me just a minute. I'm waiting for a copy of the order I need to give to you. Can you raise your right hand? Do you solemnly swear or affirm the testimony that you're about to give in this cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, so you are Investigator McNaughton,
Yes,
correct?
Your Honor.
Okay. You were not placed under the rule. They weren't anticipating on calling you, so now you are going to be subject to the rule. And I'm going to give you the written standing order that applies to all witnesses that testify in this case. So going forward, you have to abide by that order, okay?
Yes,
and I'll hand it to you before you leave. Go ahead, State.
Thank you, Judge. Mr. McNaughton, or Investigator McNaughton, could you introduce yourself to the jury and spell your last name for the court reporter?
Sure. My name is Scott McNaughton. I'm a criminal investigator with the District Attorney's Office here in San Antonio. My last name is spelled MacNaughton.
And currently, what unit are you assigned to at the District Attorney's Office?
Currently, I work with our Ethical Disclosure Unit and Administration. Prior to that, I was with Public Integrity.
And while you were with the Public Integrity Unit, were you assigned to this case, the Michelle Barrientes Vela case?
Yes, at one time I was assisting on this case.
And do we know each other?
We do.
Do you recall that while you were assigned to this case involving Michelle Barrientes Vela, whether you were present for a meeting between Les Sakanovic and Don McCraw?
I do remember, yes.
And during that meeting, do you recall whether it was about grand jury summons and records pertaining to that?
Yes, that was my understanding.
Do you recall anything specifically about what Don or Les discussed regarding those records?
I remember that it was explained to Mr. Skanowitz what a business records affidavit indicating that records didn't exist, what that was. I don't remember all the details, but I remember that was part of that conversation.
Pass the witness.
I never call you Investigator McNaughton, right?
You don't have to.
Okay, Scott?
Yes, sir.
You don't know any details specific. I mean, so you're just here to testify to a meeting that Les and Don had at one point?
That's correct.
You're not here to testify what was received at that meeting or when Don, or what Don did when was received at that meeting? None of that, correct?
No, just that I was there.
Thanks, Scott. That's what you should.
No further questions, Judge.
Okay, thank you. I did hand you the order for purposes of the record, so you're now subject to the rules. Can't watch anything for the
Understood. Thank you.
All right, ladies and gentlemen, we're going to break for lunch until 1:45. At that time, we should have Texas Ranger Bradley Freeman back on to testify, okay? So enjoy your lunch, 1:45.
All right, then, Jake. Okay, sir.
Thank you. You may be seated. State, call your next witness.
The state calls Texas Ranger Bradley Freeman.
And Ranger Freeman, we did swear you in a couple of days ago,
Yes.
and we went over the standing order, so you remain under the same. You may proceed.
Thank you, Your Honor. I'm going to hand you what's marked as State's Exhibit 1, previously marked from your first testimony. And what is this?
This is my case report from this particular case.
And how many pages is it?
Right, it's 94 pages.
Okay, I'm going to let you use that to refresh your memory.
Okay.
The first time you testified, we somewhat limited your testimony to the procedure warrant, so now we're just going to proceed through the case investigation.
Okay.
So, when were you first involved with this investigation, if you can remember the date? I believe I'll ask you to page 4, 1.3.
Would be May 9th, 2019.
And I believe earlier you testified to how you can receive an assignment on a case. And just to refresh the jury's memory, how did this case come to be assigned to you?
So the Rangers have a policy whenever there's an investigation that deals with a public official or elected official that we be requested by the district attorney's office. In this particular case, because it's an elected official, we have to get a letter from the district attorney's office. I got said letter. That letter will accompany a memo that I write, and then it goes through the Ranger chain of command to the chief to approve it.
And was it approved?
It was.
So, as related to the investigation of Rodriguez Park, in Your Honor, I'm going to, in order for this to be expeditious, I'll direct him in his report about the subject matter of what I'm speaking with, since it's 94 pages long. Does anybody have a problem with that?
I would rather him testify to his memory in his investigation and use that to refresh his memory if needed, Judge. So we object to that.
Well, he can, but she's saying can she direct him if he needs to refresh his memory, can she direct him to the case?
Yes, Judge, but that's
Yes. If he needs to recollect, please.
Okay.
Correct.
So is it related to your investigation? What was your understanding as you were beginning the investigation as it related to Rodriguez Park? I would direct you to page 4, 1.3.
And then if you can tell us if you need a review report, then we know you're trying to recollect.
For clarity, this means that he doesn't remember on his own, so he has to refresh his memory?
That's why I said he needs to clarify with us.
So if you remember, without referring to your report, what is it that you remember?
There was a complaint or an outcry about an incident at Rodriguez Park.
And do you recall the specifics of the incident?
It was an incident during Easter, if I remember correctly, and there was a citizen that I believe he initially made a police report. Yes, he did make a police report, excuse me, and also went to the media, to public, complaining about having to pay for security at the park where he thought it was free.
And in order to walk through your investigation, I'm going to go as chronologically as possible. So, after, this is May the 9th of 2019, what were were the first steps, if you recall, that you took to begin the investigation looking into Rodriguez Park?
Well, we reviewed open source media, and then once we got the approval to investigate the case, we started issuing grand jury subpoenas to start gathering information.
And did you have an occasion to meet with any of the, excuse me, the Bexar County Parks individuals?
I did. We went to the Bexar County Park officials. Can't think of his name, but we did that to try to get a better understanding of what the policies were.
I'll direct your attention to page 6.
Thank you.
S4.
So again, we went to the park official. It's not on page 6.
It's S4.
Oh,
Down at the bottom.
yeah, all right. It's page 8.
I guess you know what? You have a different report than I do. I have a 63-page report. You have a 94-page report. Sorry. I'll refer to the S.
Okay. Judge, I need to. There's something.
Ladies and gentlemen of the jury,
I'm going to give you a quick break so we can take up a matter outside your presence.
All right, the jury.
Thank you. You may be seated. We are outside the presence of the jury.
His concern is one of the things that was discussed with the parks individuals was that some of the complaints about parks that he was investigating went anywhere from the price of security to rude behavior of the constable. It talks about the parks officials said the constable had on many occasions acted in the capacity of the administration for the park. What she would tell park officials and administrators about opening and closing the park. He's concerned that that would be something he is not able to go into, even though it was part of his investigation.
Valid concern.
Right.
Yeah. It's a legitimate concern, Judge.
Yeah, I mean, how can we address this appropriately?
He can stick to what happened. Jesus raised his complaint.
However, the investigation was beyond that. It was the Rodriguez Park investigation related to the park activities first got his attention based on Jesus Reyes, but there were other concerns, so he was looking into...
But what is the purview of the grand jury? What does the grand jury investigate if she was rude? Does the grand jury investigate if she is speaking as if she's the administrator of the parks, but it's really someone else?
Well, that goes to official oppression because that goes beyond her capacity to have authority over a park. And Ken McGlamory did testify to the fact that as far as encounters with patrons at the park, it was the park personnel who would correct or engage the customer. They would supply options at that point, and if they needed to enforce any violations of law, for instance, having somebody removed for criminal trespassing, then they could turn to the constable as a peace officer to enforce those. However, it was not her job to enforce what the parks job was to do as a parks employee, and he did testify to that.
I believe he said it was his preference, Judge.
Well,
I mean, and so, but again, to your earlier point, Judge, I mean, she's being charged for tampering with evidence, and we've had testimony about Rodriguez Park, cash logs, Jesus Reyes, all that's fair game, we believe, Judge. I don't think anything outside of that goes to your previous ruling.
Well, and he did say that it started with, the investigation started with Jesus Reyes.
Right.
I mean, he just now said.
Right.
but the grand jury, you're talking about the purview of the grand jury, and the grand jury subpoenas were far broader. We had to look into the matter.
But which one is specifically to this indictment?
Well, but part of the indictment has to do with a criminal investigation was pending, and the criminal investigation involving Rodriguez Park was more than just the one issue with Jesus Reyes. That's what I'm stating.
It's the Rodriguez Park cash logs. That's what's in the indictment. So.
However, there also is an element in the indictment that has to do with an ongoing investigation, and the ongoing investigation subsequently caused numerous grand jury summons to be issued to collect evidence towards figuring out what had occurred, what might be a violation of law. And
what you just said is perfectly acceptable. He can say he was investigating. It had to do with the Rodriguez, that there was several subpoenas that were issued to her, and he needs to, I mean, you can talk about it in general terms, but to say that she was rude and she was taking on, Ken's authority, or all of that is just not relevant to anything that we want to talk about in this indictment. I mean, I think it's fair game to say that he was investigating. There was several summons that went out.
It's already in evidence.
Just like what Don described, it is to collect evidence to see if there's a violation of the law.
so I will be asking him about what offenses he was investigating at the inception, and I will tell you, at the inception, from day one, May 9th, 2019, he was looking in the offenses of theft and official oppression. Directly related to Easter and the incident with Mr. Reyes.
Is there an indictment for official oppression related to the Easter?
Not a subsequent indictment, no. But just because there's not a subsequent indictment doesn't mean that wasn't what the investigation was about.
Yeah, I don't see how you overcome the more prejudicial than probative.
Because we
I think he needs to stick to what you said.
Well, and in fact, in remind the court, we've already offered to stipulate that there was an ongoing investigation, and so that removes all the probative value for what she's trying to do, and the only thing that remains is prejudicial effect. If we say, look, we agree that there was an ongoing investigation, then to say all the different things that there were, it's just prejudicial.
We're not doing that. We need to stick to his investigation of this case.
Well, this was part of the investigation of this case, specifically to that day.
It is more prejudicial and probative. It's not coming in. We cannot talk about her being rude or civil rights or EEOC or whatever else.
That's the other indictment. But you're saying I still can't say the offenses he was looking into?
No. Suffice it that it was in response to a grand jury criminal proceeding. Yeah, you can talk. That's in the indictment.
Right.
A grand jury criminal proceeding is in the indictment. He can testify to that he was investigating crimes.
Some of the grand jury subpoenas were issued related to those other matters.
Right, but she didn't. The documents at issue in this case are not related to those other matters.
Yeah, but you're splitting two different issues. The first issue is the investigation as a whole that was under the purview of the grand jury. Just because it didn't end up in indictment doesn't mean it wasn't part of the investigation, and that is one of the elements of the offense, because this offense didn't happen until after the fact. So you're trying to distinguish that he can't talk about his investigation, his whole investigation, only what resulted in an indictment. That is not what the element goes to. It goes to the whole investigation because she has to have the knowledge that there was an investigation going on. At the time, it was the whole investigation. It wasn't limited to what she was subsequently indicted for.
We talked about the summons she received responsive to everything Susan testified to, which is the Rodriguez Park cash logs.
Well, there's other Rodriguez Park grand jury subpoenas that she was receiving at the time that go to other issues of Rodriguez Park, which,
as those are not on trial right now. We're doing Rodriguez cash logs.
But it was what the element of the offense in the indictment goes to what did that she knew that there was a grand jury investigation. That goes to her knowledge of what the grand jury investigation entailed, and it entailed something beyond just the cash logs.
But why do we need to get to beyond the cash logs?
Because that's what we decided we wanted to indict her on. It wasn't because other things were not happening.
Okay,
We don't get limited just because we don't indict somebody on something. This was a result.
If someone is investigated for murder, sexual assault, invasive, digital recording, and drug possession, but you only choose to go to the murder, on guilt, innocence, you're telling me that you're going to go into all those other things?
In their indictments, it doesn't list that the grand jury investigation is an element of the offense. This is entirely different.
And I'm not prohibiting you from asking the ranger if he was investigating pursuant to a grand jury criminal investigation.
And he was, but you're limiting on what he can say about that grand jury investigation.
So that violates all of the 404, 403.
But it's still an element.
And it's not more probative than prejudicial. It is more prejudicial than probative. So he can testify he was investigating pursuant to the grand jury, and take it from there. What happened?
He's going to try to just tell me that he can't answer that, and I'll move on.
That's fine.
We'll try.
I mean, you know the substance of my ruling.
Yes, I do. Yes, ma'am.
But I just want to make sure it doesn't leave a false impression in front of the jury if he says, I can't answer it, that there's something else out there looming. He can talk about there's an investigation. I think there's even testimony that's just he was investigating Jesus Reyes. That's been before the jury. We don't have a problem with that. But to say he can't answer that as if there was something else looming, that leaves a false impression.
He's not going to say he can't answer that. He's just going to look at me. And I'm going to try to get the signal that he can't answer that. I will do my very best so we're not doing this constantly because you have read this report. You know how detailed it is. He goes into great detail.
Well, about a lot of things that are outside this indictment. I agree.
Yes, and we're trying very hard, but it's difficult to parse out. It's one thing to not talk about the act perjury, the arrest of Moreno. What's difficult is to not talk about Rodriguez Park. We have to know where to stop and what he can and can't say about his investigation with Rodriguez Park. It's going to happen a lot because his report is written where he's grouped Rodriguez Park investigation details together.
I've read it many times, I know.
Yeah.
And you talk about Rodriguez Park per the judge's ruling and about Jesus Reyes and that interaction. And
I've already ruled.
Yeah,
I'm not going to
I know,
get
but
over this.
So this is going to happen. That's why I'm trying to tell you. He's going to try to just look at me that I'm like, okay, he's pausing. He's not answering because he can't answer so that we don't have to do this constantly. We'll try. I don't know how successful. If I don't take the clue, then say the same thing again.
Yes, ma'am.
Bring the jury in, please.
So we were at the point that you met with some parks individuals.
Correct. We met with park supervisors, and we also met or talked with another police officer, Mark Olivares.
Okay, let's start with your meeting with the park individuals. Were these the higher-ups in the Parks Department?
Yes. I don't know their exact titles. I know they were in charge of the parks.
Okay. Do you recall their names? I believe it's in your...
Ken McGlamry and Betty. Definitely wasn't just popping in my head. Betty.
Does Betty Boucher sound familiar?
Yes.
All right, so did you have anybody go with you when you met with them?
Yes, I was working in tandem with my FBI partner. Her name is Sandra.
So at that time, did they provide you with any documentation?
Yes, they did. They gave paperwork and one of the pieces of paperwork included a receipt from Constable Vela's office.
Okay. And do you recall any other documents they might have provided you?
There was a lot of, yes.
Okay, let me show you some examples.
only there to show the new ones or have already been submitted?
I believe these have been admitted States Exhibit 57, which is the,
That was it.
and States Exhibit S4.P2-1.
Yes.
So I'm going to hand you what's marked as States Exhibit 57. It's an 11-page document. It's been previously admitted into evidence. It's the code for the parks, code and regulations. So is that one of the documents they gave you?
Right, this is one of the documents.
Okay, and then I'm going to hand you what's marked as States Exhibit S4.P2- sorry, S4.P2-1. This has previously been admitted in evidence. It's the security agreement for Rodriguez Park related to Rita Fernandez on April 21st of 2019 as the date of the event. Is this the receipt you were just referring to?
This is the receipt we're referring to, yes.
Okay. When you were with Ken McGlamory and Betty Boucher, did you acquire overall information related to the Easter Sunday incident?
Yes, part of our goal was to get a better understanding of how the parks worked, how the precinct worked, how security was assigned, and things of that nature. That was the gist of our meeting.
Did they further explain anything about Easter Sunday holiday county plan in general?
Yes, they explained to us how.
Assistant?
Did you acquire information about how Easter Sunday and the county operate differently on a normal day?
Yes, I did.
And did you have occasion to meet with Officer Mark Olivares?
Yes, I had a conversation with Mark Olivares.
And did you learn any more detailed information regarding how Easter Sunday was run that day?
Right. So what we learned is on Easter Sunday, and I guess it's just Easter.
Judge, object to your saying?
That's already in evidence. Just going about what you learned.
But what he knew at the time is relevant, and it's hearsay at the time.
It is hearsay, sustained.
So did you acquire an understanding of how Easter Sunday works with the county?
I did.
So subsequent to that, did you begin issuing grand jury subpoenas?
I did, yes.
And Your Honor, I have in my hand State's Exhibit 47-1, 47-2, 47-3, and 47-4. I know that they were previously discussed.
Yes.
but not admitted.
That's right.
I'm going to hand you what's marked as State's Exhibit 40-1, 2, 3, and 4. 47-1, -2, -3, -4. Just take a moment and look at those and see if those are the grand jury subpoenas that you were just speaking of.
Yes, they are the grand jury subpoenas that we were speaking of.
And did you write those grand jury subpoenas?
I did.
And are they related to your Rodriguez Park investigation?
They are.
So I'd like to direct your attention to the first one dated for June 11th, 2019. I believe that is State's Exhibit 47-1.
Yes.
And just for identification purposes, is the date that I signed it is what date?
The date you signed it is June the 11th
Of what year?
of 2019.
And when did you serve it?
I believe I served it the same day as per my report.
State would move to admit State's Exhibit 47-1. There's also a business records affidavit previously provided to defense counsel on all of these.
Need to expect it, Judge. Judge, may I look at all of them at the same time to save some time?
Do you need a copy of my business records affidavit?
Judges, for efficiency, we don't have objection to any of these.
That's 47.1234.
Yes, Your Honor. Yes, Judge.
Those are admitted.
So I'm going to hand you State's Exhibit 47-1. What are you asking for in this grand jury subpoena?
Right, so this was taken directly from the information I got from the parks when we went to interview them, from the parks administrators. And it's specifically asking for Rodriguez Park security assignments. And the reason I asked for it that way is because I had in my hand, I knew it existed, a Rodriguez Park security assignment.
That receipt we just talked about?
Yes.
Okay. So you knew it was called a security agreement?
Yes, and that's exactly the words I used when I went to ask for the paperwork.
Okay. I'm going to go through these really quick so the jury understands the four things, and then I'll come back to this one.
Okay.
So let me hand you what's marked as State's Exhibit 47-2. What were you asking for in general on this one?
Okay, so here we had seen a video that I considered a witness statement, and it was related to Rodriguez Park. And here I asked to provide any audio or video recordings from Rodriguez Park that recorded any employees of Rodriguez Park.
Okay.
Again, I knew it existed because we had seen it.
Okay. And then I'm going to hand you marked as State's Exhibit 47-3. In general, what were you asking for there?
Here we asked for any reports that dealt with Rodriguez Parks. That included incident reports, case reports, anything that was provided on Rodriguez Park.
Okay. And when you say incidences, what types of, which agency were you looking at?
I was just trying not to read it.
Okay, it doesn't matter, it's in evidence.
Okay, all right, very well. Perfect. All reported investigative assignments for deputies directed by Constable Michelle Vela and or any self-initiated investigative reports dealing with Rodriguez Park. And we put the address of the park.
I'm going to hand you what's marked as State's Exhibit 47-4. What were you asking for in this one? And we'll go into detail, but I just wanted them to understand what just got admitted.
Okay, again, we were asking for security records, deputy police officer assignment schedules related to the security at Rodriguez Park. And we have the dates and times. And we went a little more specific.
Okay.
Yes?
Yeah, we'll go into that
Okay,
later.
all right.
So let me redirect your attention to 47-1. So you had just previously testified that you believe you served it on what day?
On the 11th of June, 2019.
And who did you serve it directly to?
Well, to the office in general.
No, I meant like, who did you physically hand the grand jury subpoena to? Can you recall the circumstances under which you served this document?
Right, I remember having to sign in And
Sign in where?
at the front of the office, there's a sign-in book there. I was a little hesitant to do that, but at any cost, I signed in. And
Are you talking about the precinct?
yes,
Okay, so you went to precinct 2.
yes.
And so what happened after you signed in?
I waited because I asked them if I could serve the constable. And for the life of me, I can't remember if I gave it to her personally or if I had to leave it with the clerk or one of her assistants. At any cost, I know she got it because she called me.
Okay, so, all right, so now if you'll refresh your memory from your report, it might help you. If you look at 4.6.
Yes, I have noted she received it, the subpoena personally at her office. Excuse me.
And what does that mean to you that she received it personally at her office?
I gave it to her physically.
Okay. So after you served, so I know I keep having you refer back to your report because I want the jury to be clear what actually occurred versus our memories as time goes on. And so would your report be more accurate than possibly your memory today?
Yes, I just didn't read it closely enough. I apologize.
That's okay. And that is why you make a police report, right?
Yes.
Okay. So on the next day, do you recall what occurred?
Yes, I got a phone call from the constable basically seeking clarification on what she wanted, on what we wanted with the subpoena. And I explained exactly what was here, that we were looking for the Rodriguez Park security assignments. And her reply was, well, it's not going to be that much because mostly myself and the chief work these things.
Who was she referring to? The chief? Did you know who that was?
Chief Anthony Castillo.
And based on her reply, what did you inform her, if anything?
I told her I'd be looking for any scheduling information that she could provide.
At any time, did you direct her that she needed to recreate records?
No.
And would you anticipate that as a requirement under a grand jury subpoena?
To create records, no. Just we're asking for what you have.
And you were not at any time in your investigation looking for a violation of retention of documents, were you?
No, ma'am.
So when you were wanting scheduling information, what types of information were you looking for regarding a schedule?
Well, because of what we learned from the Parks Administration, I anticipated that there would be a log, receipt books, and because of what we were given by the Parks Administration of the deputies who worked, when, how, because you're taking money. So, yes, that's what we were looking for. We were just looking for those records.
Okay. And on the same day, during this phone conversation, was the constable satisfied with the explanation for clarification?
Yeah, she seemed to be satisfied. She just made the comment that there's not going to be much because myself and the chief deputy mostly work these events.
Okay, and did she express any other concerns that she may not be able to respond to the grand jury subpoena fully? Or is that it?
I don't have anything noted on my report to that nature.
Okay. So on the same day, did something else happen related to your investigation with Rodriguez Park?
So that would have been the next day when after I got the phone call from the constable, I was contacted by a clerk that worked in the office.
And what is the name of that clerk?
Her name was Susan.
Her last name?
Tristan.
And she contacted you?
She did. Because I signed in, put my phone number on that piece of paper there in front of the office, she grabbed it and called me.
And what did she call you about?
She was concerned. She expressed to me that the constable was a little rattled by getting the grand jury subpoena.
What Susan said, no.
Sustained. Jurors disregard the answer, was what Susan said.
Did Susan express any concerns about her possible role in the grand jury subpoena document request?
Hearsay, Judge.
Concern. Did she express, that's a yes or no answer, so that is overruled.
Yes, she did.
Were you able to subsequently learn any information about the Rodriguez Park procedures and further learn about how they worked through that conversation?
I was.
Did she express any desire to meet with you in person?
We both coordinated to talk and meet more, yes.
Did she at that time want to provide any documents to you?
Yes.
And were those documents identified? That she wanted to, did she call them by a name? Like,
Yes.
and what type of documents was she identifying?
A receipt book.
And what did you understand a receipt book to be?
You know, the carbon copy papers where you're writing a person's name and amount of money, yellow and white, just a basic receipt book. That's what I felt like she was going to give me.
Okay. And on that, so did you set a time to meet?
We did.
And when were you going to meet with her?
We met with her the next day, the 13th of June.
So let's go back to what occurred the rest of the day that we're on. Did you speak to any other witnesses on that day? I'll direct you to 4.8.
Yes, I also spoke to the officer, Mark Olivares, the one who was taking care of security for the commissioners for the other parks.
Did you ask him to provide a statement?
Yes, I did.
And did he ultimately do so?
He did, yes.
So let's move to the next day. Before we get started online. So you previously stated you first were assigned the case on what date?
Sorry. Yeah, it's at the beginning, but on the 9th of May.
Did you meet with the district attorney's office regarding this referral? If you recall.
I can't imagine that I didn't. I have noted here that we talked with the chief,
And who?
Del Prado.
My chief.
Yes, ma'am.
Okay, and at any point in time, did you request that I be assigned this case?
No. That's none of my business.
So,
far as the timeline of events, then on, you had previously testified that June 10th, 2019, you met with these park people. Is that correct? I just want to be sure with these dates. I know you've already testified.
Yes, ma'am. June 10th, 2019, we met with the park officials.
And then that's when you received the 2 documents we already described.
That's correct.
And then you stated on June 11th was the first grand jury subpoena.
Yes, ma'am.
And then you stated that, was it the next day that you received a phone call seeking clarification?
Right. The 12th.
And that same day, is that the same day you said that Susan Tristan contacted you?
Yes, ma'am. That is the same day I was contacted by Susan. That's also the day I talked to Marco Olivares.
Did Mark Olivares state that he would provide you with any documentation?
He did.
And what type of documentation was he providing you?
Mark gave, he sent pictures
Pictures related to what?
to the Easter incident, pictures of vehicles, unmarked county issued units is what it looked like.
And do you recall what else he may have sent you?
I have noted here that he gave a statement. Well, no, I said I'll update this report once a statement was received.
Okay, so you just had requested it at that time?
Right.
Okay, so then, did anything else happen on June 12th that you recall?
Other than the constable calling and Susan calling and speaking to Mark, it looks like we moved to the next day.
Okay, so the next day is what date?
The 13th of June.
And what occurred on that day?
We met with Susan. I met with Susan. I'll put the address here. I don't know how relevant that is, but we did.
It wasn't any type of office or anything like that?
No.
Some kind of commercial business or?
Right, it was, whatever's that,
Whatever's there.
45, okay.
It's not important. Did you receive any kind of documents from Susan at that time?
Yeah, that's when she gave me a copy of the receipt book from the Precinct 2 Constable's office.
Your Honor, I know I've been driving your court reporter crazy with my numbering system, so I have abandoned my numbering system, and I'm going to go just to state specific. Can you tell me the next specific number?
Yes.
I'm assuming everything in between that you haven't marked anything is because you have something in there.
Yes.
Okay. Now, so the next one that's not marked is 73.
Thank you. So I'm going to hand you what's marked as State's Exhibit 73. Do you recognize this?
Yes, this is the copy of the receipt book Susan arrived with.
And can you flip through to make sure that that isn't the only thing you received? I can't recall.
Included is just written on loose leaf paper, dates, dates, amounts. And officers' names.
Okay, and then...
Some of them have officers' names.
Okay, and then the very last page is another document?
Yes, looks like another type of schedule. Has birthday parties, Rodriguez Park, where they were going to have these parties.
Okay. Your Honor, I move to admit State's Exhibit 73.
Can I take him on to short word, Judge?
Yes.
Ranger Freeman, so you just testified to this jury that you received from Susan Tristan on the 13th. May I approach, Judge? Receipt books, correct?
Yes.
That's not all that's in there, right?
Right.
And there's cash logs in there.
Yes.
Why didn't you say
Well, yes, there was something else in there. I don't know if we can call it a cash log.
Well, let's look at the top of the page.
Oh, yes, yes. Clearly says cash log, correct.
Clearly says cash log. So it wasn't just the receipt book that you received from Susan Tristan.
That's right.
It was cash log, correct?
Yes, sir.
And a handwritten paper?
Yes.
May I approach one more time, Judge?
Yes.
Well, not one more time, another time. Just to be clear, this is some handwritten notes, sorry, handwritten notes there? It's a copy of handwritten notes, correct?
Correct.
And
Copy of handwritten notes.
And there's information on there.
Yeah, there's dates, receipt numbers, names of officers.
And then also on this back page, seems like a list with some names on it as well and some handwriting on the bottom.
Right.
Do you know whose handwriting that is?
I have no idea.
No objections, Judge.
State 73, is that it?
So, the jury's been watching you, and I actually refer to your prosecution guide, and I call it a prosecution guide. What do you call it?
A case report.
So, just so they understand how it is you know what you were given on a certain day. Can you describe how your report is set up? So how it ties it to the day's events?
Right, so if I get something like we just showed here, I'll write a note about it, and then I'll attach that, and I will label it per the report. So this was report number 5, and this particular item was labeled supplement 5, which is report number 5, piece 1. And it just basically says copy of the receipt book from precinct 2, which we had pointed out it had more than just the receipt book inside.
So that is just so you can generally have a title to the item you received?
Yes, ma'am.
And so to the left of the description of copy of receipt book, it would say S5.P1.
That's what it says, yes.
It's the very numbers that have been driving the court reporter crazy that I've used. So.
It's not the best, but it works.
So I'm going to hand back State's Exhibit 73 to you. And so what is can you read the very first receipt number? I know it's really...
Oh, mercy.
Hey, yeah.
Okay, 439421.
I'm going to hand you what's marked as State's Exhibit 30-1. It's already in evidence. Is that the first page that you see there? I can't, or you might have to flip through pages.
Okay.
Yeah, if you can look for the same receipt. I'm just trying to match it up to the evidence already in admitted.
Okay. So sorry. It appears this one is 439401.
Okay, so flip through where you might think you would find that. Oh.
And here it is.
Okay. So when you said here it is, what are you pointing to?
This matches what I received from Susan, this book that is marked, that exhibit.
Okay, I'm going to, may I publish the jury, Your Honor, State's Exhibit 73?
Yes.
So this is the previously admitted receipt book that we've all seen several times. I'm going to place on the monitor this page. It's very pale, but I think you can tell from the two that it's referring to the same. So based on this document you received, what does it appear Susan has done to provide this to you?
It looks like she made a photocopy of that yellow book that you have in your hand.
Okay. to hand you back State's Exhibit 73. I'm going to hand you what's marked as State's Exhibit 31-2-6, previously in evidence. Does that appear to be a copy of the same? Maybe not.
It's,
Here, let me try to. I can't see. You're so tall.
so it is, but there's more here.
Oh, I see. So there is a difference.
Right.
Okay. So let's talk about the difference between the two. Does it begin to be the identical statement?
It starts off as the same, yes. However, on the bottom there are 3 additional entries that were not on the copies I was given by Susan.
Okay. So let's show that to the jury. So I'm putting on the monitor State's Exhibit 31-2-6. This is one of the previous cash logs we've been looking at, and you've just stated it appears to be completed to the bottom.
That's right. Yes, ma'am.
So I'm going to place this as close as well, if you'll just look at this, you've compared the two, and it appears to be the same document up to a point. It's just missing the bottom entries.
That's correct.
So at the time she was able to copy this and give it to you, it seems like afterwards more information was filled in later.
Yes, ma'am.
So I want you to take a close look at State's Exhibit 31-2-6 and what she provided you, and see if you can ascertain the entry dates that differ.
Okay, so on the one she gave me, the last date is June the 15th.
I'm sorry, Ranger.
Yes, ma'am. Susan Christian.
Okay.
Tristan, excuse me.
Thank you.
So Susan, the item that Susan Tristan gave me, last date of entry was June the 15th. On this one, there is additional dates for June 22nd. There's another additional, but it does not have a date. There's yet another one that this date may be associated with it, 6/23. There's another one without a date, and there's another one without a date.
Okay.
So there looks like 5 new entries, starting with June 22nd.
And your conclusion of how those entries could be on State's Exhibit 13-2-6 versus the one she provided you?
Somebody wrote them on there.
Okay. Just at a later time.
Yes.
And it could be simply the entries came at a later time from when she met with you.
Yes, ma'am.
Okay. The next page I'm going to hand you what's marked as State's Exhibit 31-2-8. Can you compare the two of those?
Yes. They appear to be identical.
Are there any differences between the two, if you see any?
Not that I see.
Okay. So, just so the jury knows what we're talking about, this was what they've already seen, State's Exhibit 31-2-8, and this is what Susan provided to you in State's Exhibit 73. And the last entry appears to have completed the entries. to the next page of States 73. I'm going to hand you what's marked as States Exhibit 31-2-7. Does that appear to be the same?
Yes, I don't see any changes on this.
Okay. So the jury has previously seen 31-2-7, and now here's the same copy as provided in Exhibit 73 by Susan Tristan. Appears to be the same. I'm handing you State 73 with the next page. And States Exhibit 31-2-4, if you could compare the two of those items.
These two appear to be the same.
I'm showing States Exhibit 31-2-4, which we've previously seen, and the copy as provided by Susan Tristan appears to be the same. I'm handing you States Exhibit 73, the next page, and States Exhibit 31-2-5, if you compare the two.
And these appear to be the same.
Okay. -2-5 as previously seen. I'm showing States Exhibit 7, the copy as provided by Susan Tristan. Appears to be the same in States Exhibit 73. There appear to be more receipt copies. Some of these are upside down because that's how it was provided. I'm going to hand you a page with handwritten receipts and find. I'm going to hand you marked States Exhibit 31-2-9. It might have something on the back, so you may have to find the subsequent page as well. So, could you please compare those and see if they're the same? It might be that she didn't provide the back. I don't.
Yes, with the exception of the back, these two are the same.
Okay. I'm putting on the monitor States Exhibit 31-2-9. It was previously identified as the handwritten cash logs created by Constable Vela. I'm going to show the jury States Exhibit 73, the same copy that appears to be the same. I'll hand you States Exhibit 73 and the next page. I'm going to hand you what's marked as States Exhibit 31-2-11. It's a double-sided document as well. However, it's possible both sides are not included in there. Just check to be sure.
This side is the same, but there's significant stuff over here.
Okay, so the one that's donated on the back side of 31-2-11 is indicated in the bottom right corner, page number what?
5.
Okay, that appears to be the same?
Yes.
And how about, what is the next page?
It looks like it could be a 6.
Okay, so I'm going to give you States Exhibit 31-2-10 to see if you can compare these two as being the same document. It is also a double-sided document, so check for that. So is the back included on this one in her copy?
No, it's not.
Okay, so these two States exhibits that I just handed you, 31-2-11, only had page 5, not page 4. And 31-2-10 only had page...
Looks like page 6 and not 3. It's not? That's a 2? Okay.
Okay.
Yes.
So
Sorry.
page 3 and 5. Okay, so let me have that back. So I'm just going to show the jury States Exhibit 73, the 2 pages as provided by Susan Tristan. The one denoted page 5, which you see before, and page 2, which is upside down, as you've seen before. Now I'm going to go to the last page. Of States Exhibit 73, I'd like you to compare it to Defense Exhibit number 10. Does it appear to be the same document?
Yes, they are the same.
I'm showing on the monitor Defendant's Exhibit 10. This is the document that has been previously admitted. It's a handwritten, I don't know what to call it, a receipt, I guess, of maybe what had occurred out on April 21st of 21 regarding Jesus Reyes, and this appears to be the same document, although it's even better copied. So what we went through on State's Exhibit 73 was what Susan Tristan provided to you on, what day?
On the 12th of June.
Okay. That's right, 13th.
Yeah, sorry.
Thank you, Mr. Levesque. So did she provide anything else to you on that day besides State's Exhibit 73? And please refer to your report if you need to.
No, ma'am. What was included in the receipt book and the, looks like cash logs, that is what she gave me.
Okay. So, subsequent to this meeting, what was the next thing that you did on this case of investigation as it relates to Rodriguez Park?
Okay. Later on the 19th, my partner and I from the FBI met with Miss Susan Tristan at the FBI office.
And what was the purpose of that meeting?
We wanted to just get a better understanding of what she knew, what she did, and basically everything that was going on. She reached out to us, so we wanted to make sure we understood what she was telling us.
And did she go through, let me just ask you what, in general, without saying what she said to you, in general, what were the topics that were covered?
She talked about what her duties were at the precinct.
Did she explain how the reservations process works?
Okay, that's fine. Yeah, she did, yes.
And did she explain what her job was in relation to?
15.
Let her finish the question. Did she explain her job as it relates to scheduling customers?
She did, yes.
Girl.
Just a reminder, Ranger, if there's an objection, you gotta wait for me to rule on everything.
Yes, ma'am.
Did she explain how the customers come in and make their reservation?
Yes, ma'am. She explained the whole process, how they came in, what the protocol was, what she did with the paperwork.
Okay. Did she explain that cash was received in the precinct?
Yes, she did.
Did she explain her role in regards to the receipt of that cash?
Yes, ma'am, she did.
Did she explain who the person is that received the cash from her?
She did.
And do you recall who it was that received the cash from her?
Objection, hearsay, Judge.
That is hearsay. That's the same.
Based on your investigation in learning Susan's role, did you ascertain who would be the person who received the money?
Judge, the answer comes from hearsay.
Sustained.
Did she, was she able to tell you what the hourly rate was for the customers?
She did.
And what was the hourly rate?
$50. I'm sorry, excuse me. According to my report. But never mind.
So it's $50? Oh, hold on.
8.5.
I'll move on.
Judge, the instruction in disregard since it's wrong. I don't even know what happened.
Oh,
It's fine. Keep going.
can we approach?
Oh, no. Yes.
Do you recall how long your meeting might have been with her? You may not have denoted it, I just was wondering if it was a long meeting or...
I mean, we talked at length.
Okay.
I'd be guessing if I told you a time.
That's fine. So during the course of your meeting with Susan and part of your investigation, what is your goal in this in an investigation in general?
Get as much information as you can, find the facts.
And is it because you're seeking to file a charge on somebody, or is it because you're just trying to figure out what happened?
No, I mean, you issue these, you go into an investigation trying to find the facts. The innocent or guilt will fall as it may. It's just not the goal. The goal is to get every answer that you can.
Well, in the course of your career, do you have any idea how many investigations you've done? I mean, just hundreds, thousands?
I would put it in the hundreds, yes, ma'am.
And in every single one of those investigations, do you seek to file charges?
No, like we said the first day, there are plenty of times when the facts point that this particular person did not do anything that was against the law. And that's just as important as finding that they did.
And in your career, has that happened often?
That's happened before, yes.
So during the course of your meeting with Susan Tristan, did she provide you any more documentation?
Yes, on this day she gave a couple of statements that she had written in reference to Rodriguez Park. She was asked to make.
I'm going to hand you what's marked as State's Exhibit S8.P3A and S8.P3B. Sorry. S8, as in the number 8, .P3A and S8.P3B. I'm handing those to you. Is that what you were referring to?
Yes.
And when she gave you those, was any explanation provided as to the origin of those documents?
I mean, she was asked to give a statement by the constable about paperwork related to Rodriguez Park.
And what did she say to you about that first draft on A? It's already in evidence. It's already in evidence.
Well, that's in evidence, but the state's outside the court.
So in A, what is it she's describing?
It's her statement. Do I just read it?
No.
She's providing a voluntary statement.
So in general on, I'm just going to refer to it as A, in general, what was the procedure that she was going over in the statement?
She was talking about what her responsibilities were as it pertains to the reservations at the park. In this particular statement, she's specifically talking about the Easter incident with Jesus Reyes.
Okay.
Okay?
And the B version?
The B version, it's a little more detailed. It has the name. And again, it's her talking about Mr. Reyes coming back, asking for a refund, and her letting Mr. Reyes know the responsibilities at the park and what she would do.
Okay.
And it has a statement that he made in there, according to Susan.
So State's Exhibit S8.P3A is how long?
It looks like about a paragraph.
And then S8.P3B, how many pages does that appear to be?
Yeah, there's a paragraph in additional on another page.
And is the first page, how complete is that?
It's full. Well, for the area you can write in, it's full.
And then it finishes on the second page?
Yes.
So the first statement is from June 11th, 2019. The second statement, June 14th, 2019.
Right, and these are the two items she gave us when she came to the FBI office.
So far, you have met with her several times, and she is bringing you information.
That's correct.
So, I want to move on to your next step in your investigation. Do you recall when that might have been?
Yeah, so the 1st of July, that's when I got the statements from Officer Olivares.
Now, I'm going to back up. So on the last step you were talking about was June the 19th of 2019.
Okay.
Keep up with my time. So the last thing I wrote up on this timeline was June 12, 2019.
I'm sorry, Ms. McCraw, can I interrupt you? My court reporter needs to take a break.
Okay.
I'll take a break. 3:30, let's reconvene at 3:45. Thank you. Remaining meeting for
All right, Ms. Reed?
Thank you. You may be seated.
May I proceed, Your Honor? Yes, ma'am. Thank you. We were trying to fill in the timeline since I've been remiss in keeping up. So I'm going to move to 6/13 of 2019. You previously testified that you met with Susan?
Yes, ma'am.
And this is you actually meet in person for the first time?
It is, yes.
And also on the 13th, did you state that you received photos from Officer Olivares?
Yes, on the 13th. Oh, wait. Yes, he sent pictures on the 13th to me of vehicles.
And then we move to 6/19. And you testified that you and the FBI agent met with Susan?
Yes, ma'am.
Which FBI agent? Just the last name is fine.
Rivera.
And that was at the FBI office?
Yes, ma'am.
So on 6/13, when you met with Susan in person, is that the day you received the copies that we went through in State's Exhibit 73? The receipt book and all those things?
Yes, ma'am. That's when she provided the copies of the receipt book.
And is it on 6/19 of 19 that she provided you with those two voluntary statement drafts at first?
Yes, when she came to the FBI office to meet with myself and Agent Rivera, that's when she gave the two. statements.
I'm in trouble writing because this is moving.
I think I caught it.
So before we move to your July meeting with Mark Oliveris that you were about to talk about, I would like to, I know your report doesn't reflect it, but from your memory, were there times that, a couple times where Susan Tristan was provided a recording device?
Yes, we did.
And,
It's in my report too.
oh, is it? Oh.
There's a note. It's not on this. It's later on, but yes,
Oh, I see, but it refers back to,
her wearing a recording device.
okay, but was that for the third time she recorded device or the first and second?
I believe it was around the third time. Yes.
Third time,
Sorry.
okay. So who would have written a report related to the first two recordings?
Yeah, Agent Rivera would have written those.
And so that would be reflected in his FBI report?
Yes, ma'am.
I see. And why is it it's in his report and not yours?
He was present, and it's a lot of rules over at the FBI. Because he was present and he took custody of it, it's his duty to write that report.
So, do you recall the dates of the two recording devices, the first two?
Not off the top of my head, but I know they exist, obviously, right?
Right, right. Do you think it was around the month of June?
Yeah, Don, I would say we put her in there with a recorder around June.
Judge, we'll stipulate to recording device from May 22 to 26. Save time.
Okay. So does that sound accurate to the 25th of June?
Yes, ma'am.
So after that point in time, now we move into the next step in your investigation. What was the next thing you did?
We did the talk with Susan. Then we got additional information from Officer Olivares.
And on what date did you do that?
It would have been July 1st, 2019.
And the types, just in general, what did you glean from your investigation in meeting with Mark Olivares?
So Mark was explaining to us the procedures that were put.
And just what did you glean from the investigation without saying what he told you?
Sorry, Mark told us about the procedure. Sorry. Okay. It's my fault.
So after you finished your meet, did you meet in person or?
We spoke on the phone.
On the phone, okay. And did he ultimately provide you with a written statement?
We got information about how the parks operated for Easter, and yes, he eventually provided a statement.
And based on that aspect of your investigation, what part of the Easter incident do you now have knowledge of? Was it related to Mr. Reyes, or was it more overall what Olivares' role was that day?
Yes, it was about what he encountered
What Officer Oliveras encountered?
What Officer Oliveras encountered in that precinct with the constable.
Okay, and so did he relate to you with anything about the whole county setup for security that day?
Yes.
Okay. And then did you subsequently receive more documentation from him apart from his written statement?
I did get emails from him related to the setting up of security at the park.
Okay, so that further supplemented your knowledge of how the security was working from the county's perspective that day?
Yes.
Your Honor, may we approach this guy? So I'm going to move forward to July the 24th, 2019.
Okay.
So, did you have another occasion to meet with Susan Tristan?
Yes. On July 24th, we again met with Susan and gave her a recording device to take into her workplace.
And so you and she met?
Yes.
And are you the one, or who provided that recording device to her?
Do you recall?
I believe I gave it to her. I don't,
And normally, you had mentioned previously that the agent, the FBI agent had provided the first two. Why was it that you were providing the third one?
the agent wasn't available, if I recall, and so we wanted to do it this date. So we just made the exception that I would give it to her.
And prior to you providing any of these recording devices, thank you. I don't think my microphone's working, Your Honor, anymore. Thank you. So prior to any of the recording devices being given to Susan Tristan, what types of things do you talk to her? Well, first of all, did you or who suggested that she carry a recording device?
It was a joint effort. Anytime we have someone come to us and offer information, it's just an effort to capture evidence. It's a tool used by the FBI as much as possible.
Okay. And in the use of these devices, is there an occasion where nothing is ever captured of any significance?
Yes, and specifically in this case.
And prior to giving her the recording devices, do you coach her in what she's supposed to say on these recording devices in any manner? What is it that you tell her about the recording device? Do you recall? What was the purpose of giving her a recording device? Let's begin there.
We learned that she had fear of being possibly set up.
Judge, hearsay judge.
Go ahead.
We learned that there were conversations that she wanted for the record. So we gave her a way of recording said conversations. The reason I'm hesitant because there are rules that I'm not familiar with body recordings that the FBI has. Not legal. We covered our legal basis. What I can't testify to is the specific rules that the FBI has.
Sure, and these are proprietary devices that you can't speak about. There's federal law prohibiting going into those sorts of things.
Judge,
Yeah.
the counsel's testifying, Judge.
I'm just clarifying why it is he can't
Well, she's
testify.
not a witness.
Yes.
So, okay, so excluding that sort of thing, so when you gave the devices to Susan, did you explain the procedure on how she is to carry it on her?
Yeah, the one main instruction that we give people is they have to keep it on them. It has to be on their person due to the consent rule.
And what is the consent rule?
Because if it's left, and now we have basically a Title III, which is a TAP, which is monitored conversations that we are not privy to. So the person has to always keep them. That was really the main instruction that we gave Susan.
So in the state of Texas, when is it legal to record somebody?
It's a one-party consent state. A person wants to agree to wear a recording. That's perfectly legal as long as we have permission from the one person.
And so the one person, for instance, if it's me, I can record anybody I'm having a conversation with.
Yes, ma'am.
But if I'm not part of that conversation, I cannot leave the device and walk away from it. And that's what
Exactly.
you're describing?
Exactly, yes, ma'am.
Okay, so, and otherwise then it's an illegal wiretap?
Yes, correct.
Okay, all right. So, yeah, I just want the jury to understand the difference between why it is that she needs to have a device on her at all times. And so, so where is she directed to place this device?
I believe we had it on her person in her pocket, if I'm not mistaken.
Okay, and what is her ability to manipulate the device?
She can't do anything to it. It's locked in, it's on, and any tampering, they'd be able to tell.
Okay, and so you meet with her in the morning and give her the device and meet at the end of the day and pick it up.
Yes.
And if it runs out, it runs out. If it keeps running, then it keeps running.
Yes.
And it picks up everything.
Yes.
After the 2 dates on June the 25th, 2019 and June the 26th, 2019 recordings, you had stated that it was Agent Rivera's, he was the one facilitating the recording. Was it his job to evaluate the recording as well?
It was, yes.
And he did so?
Yes.
And that would be in his reports?
Yes, ma'am.
And we're going to move to the 7/24/29 recording where you were the one who actually handed it to her, but it's still not your device, correct?
That's correct.
And so when it gets returned, when Susan returns it to you, what do you do with it?
I give it back to David.
Are you even able to listen to it?
No.
So it requires special, well, I don't want to go into what it requires, but it requires more than what you have to facilitate listening to it.
Yes.
So let's talk about so I was asking you earlier about what kind of instructions you may have provided to Susan apart from the procedural on how she can carry the device. Did you instruct her on what she is to say during the course of the day where she's carrying a device?
No.
And what is your purpose, apart, you gave the purpose earlier, but is there any other purpose other than to see what appears on the tape?
No, I mean, the purpose was to capture possible conversations between her and her boss.
And was Susan ever given any special instructions on setting up the constable to say anything?
No, ma'am.
Now, July 24th, 2019, did you do something different than you had on the previous 2 recordings?
We did, yes.
And what was that?
We called her.
Who's her?
I'm sorry. We called Susan and asked if she would be available for an interview that we were going to do outside of her place of employment.
And so, in a previous conversation, was it planned that you would make that phone call to her?
We told her we were, yes.
And so she was expecting you to be calling her?
Yes.
And was she instructed to pretend like she had not had previous conversations with you? Was she instructed to not reveal that she was working with you in any way? I'm sorry, maybe I'm not making myself clear.
Let's get an answer to the question.
I don't remember, but I mean, I say that cautiously because I don't really understand what you're asking me.
Okay, I'll rephrase. When she answered the phone with your phone call, was it as if she was talking to you for the first time?
Yes.
Why?
But we didn't want to reveal that she was a cooperating witness, a source.
And what, under the FBI descriptions, do they categorize someone like Susan Tristan?
She was... That's better for the FBI, Don.
Okay, that's fine. It's fine. So, from the state side, would we call somebody like her a confidential informant?
Yes.
And when you have somebody who's a confidential informant, do you go to efforts to keep their identity confidential?
Right. You want to protect anybody that's cooperating with the state. So you do everything within your power to make sure they're kept in confidence.
Okay. So at some point during that day, you make a phone call to Susan?
Yes, I do. Make a phone call to her to invite her for an interview. And that started a conversation between herself and the people that she was working with, which would be Constable Vela.
And that phone call, was that in hopes that it would stimulate that conversation?
Sure, yes.
And was anything, so the next step was for you to arrange for a time to meet with Susan. Was that accomplished?
Yes, it was.
And what was decided?
We asked if she could meet us down the road at another police station, which would have been Leon Valley. And she did.
And why did you go to Leon Valley?
And we didn't want to take her too far away. She made it real clear to us that she was under time constraint and that she would be held accountable for such. So we wanted to make it far enough, but close enough.
I see. And at any point in that time when you were calling her, do you recall if you were speaking to more than just her on the phone?
Yeah, at one point she put us on speaker, and we could hear the constable and the chief deputy Castillo.
And were they actually speaking directly to you, or could you just hear them?
I don't remember if they spoke directly to me. I just remember them having a conversation with her about, are you under criminal investigation? Why do they want to meet you?
Okay. And so after, at some point did that phone conversation end?
Yes.
And what was decided at the end of that call?
They allowed her to go to Leon Valley and meet with me.
And did that happen immediately, or when did that happen?
No, if I remember correctly, we just set up a specific time for her to arrive there at Leon Valley.
And was that later in the day?
If I remember correctly, it was, yeah.
Okay. And had you previously decided to interview or meet with, and I call it an interview, we meet and have a conversation with Susan for that day as well? I think it's S11.
So yes, we met that morning to give her the advice, and we scheduled a phone call. We recorded said phone call. Then the agreement was for her to meet us at the police station.
And did she meet you at the police station?
She did, yes.
And the recording device was still recording, correct?
It was.
And did you forget it was recording?
Yeah, I mean, these things, like, you can't turn these things off. I didn't want to mess with it.
Now, what would be important for an interview not to be recorded when there's a confidential informant involved?
Well, I mean, you got the rules of the court, and you want to protect them as much as you can. So, I mean, part of that is not recording that.
And so a recording is a recording of a person's voice.
Right.
And can a voice identify who a person is?
Yes.
And so and does that also apply when you have a confidential informant to requiring them to provide any other form of written statement? Like, for instance, if you have a confidential informant, would you want them to be providing you written documentation of a voluntary statement to you while they are a confidential informant? I don't know. I'm just asking. I don't know if you do or don't do that. We're talking about the confidentiality of CIs.
Right. So here's the problem. The Rangers don't deal with confidential informants. It's just not what we do. We let our other divisions handle those because we don't. Now, with that being said, the FBI handles them all the time. I don't know all the rules to confidential informants.
Okay. So in this case, because she was in that category, she was never asked to provide you in your investigation a written statement.
Correct.
So, and additionally, you would not have preferred that she be recorded in a conversation with you when you're interviewing her?
Oh, no, I would, no.
So this is an oversight?
Yes, ma'am.
So during the course of the conversation, did you learn about what was being said at the precinct regarding your phone call without saying what that was?
Yes.
How long did you meet with Susan?
I have noted here we went over items related to the grand jury subpoena. And so, Don, I'm going to guess and say it was probably an hour or so.
Okay. And did she provide you any more documentation at that time?
She did. S11P1, which are marked as the cash logs from Precinct 2, Bexar County. She added that she knew these were not included in what we had asked for.
Did she explain how she knew that? Did you have Did you have an occasion to go over? Well, you know what? I gotta back up.
I want to return to grand jury subpoena that was issued on June the 11th of 2019.
Okay.
When was the response due? Oh, do you let me get that?
Here it is. Actually, I have it right here.
Oh.
June 26th. was when they were due.
And the grand jury subpoena, does it direct the constable to whom it should be returned?
It does, yes.
And who would that be?
It was addressed to be returned to me.
And did that happen for this subpoena?
It did not.
What happened?
The constable got an attorney and started sending the items through her attorney. Not even to me, they came back to you.
Okay, so let's talk about, did you receive any documents from me?
Yes, you would give me what you would end up receiving from the constable's office.
All right, I'm going to hand you what's marked the State's Exhibit 46-1 and 46-2. And Your Honor, just for purposes, has that been admitted? I'm pretty sure it has. 46-1 and 46-2.
46-1, the affidavits, the affidavit, that's been admitted.
46-2, 211-page item.
I don't think that was admitted.
Okay. All right, thank you. So at some point in time, did I provide you with 46-1, a 5-page document?
Yes, ma'am.
And was that supposed to be in response to the grand jury subpoena we're talking about? Did you ask for that?
I did not.
Okay, so let me, so I provided that to you. So let's go to State's Exhibit 46-2. It's a 211-page document. I would like you to briefly look at this to see if you recognize it.
Okay. Okay,
Do you recognize it?
I do.
And what do you know it to be?
These are items in response to the first grand jury subpoena that was dated 6/11. And I mean, it has a variety of things in it.
Okay, and was it your understanding that at this time that was responsive to grand jury subpoena that was dated June 11, 2019?
Yes, ma'am.
And do those look like the actual items that you received from me?
Yes, ma'am.
State would move to admit State's Exhibit 46-2, 211-page clip document. Yeah.
Have you ever Jeff?
Get here as early as you need to get that parking, but we start at 10:30 tomorrow, okay? Remain under the same instructions.
All right, for the jury, bring your books.
Thank you, be seated.
Do you want the witness to remain or? Yes.
Right.
Okay.
Did you say you wanted the board on?
Yes, Judge.
Yeah. All right, we're all set. Jury, Mr. Lopez, proceed.
Ranger Freeman, we've been talking in front of the jury about Stacy's Exhibit 46-2, correct? This is the one you just reviewed?
Yes,
And you testified that you received this from Dawn, correct?
yes,
And what you also were told by Dawn is that this was collected. Well, you don't even know how this was collected, do you?
no,
Or who collected it?
no,
Or who turned it in to Dawn, do you?
no,
You just know that Dawn gave you this.
that's correct.
Sorry, did we establish a date?
We did not, Judge.
Tell us the
They
date.
did not. When did Dawn give you this?
I don't have a date noted.
So you have no idea when Dawn gave this to you?
Actually, I believe that he could ascertain that date by looking at his report on S11.
No.
There came a time that he was in possession of those records for Susan to actually make the comparison. And
Yes.
so it had to have been before that date.
And that's, I mean, he's speculating, Judge doesn't say when Dawn gave these to him.
But it's a range of dates it's on or about.
Okay, so what I want to know, Ranger, is, and I may be wrong in my note taking, but you said you met with Susan June 15. Hang on. Susan called June 12th, and you met with her June 13th. And it's at this June 13th meeting that you said she told you there was stuff missing? Or that she brought you the copies of the receipts?
The talking about stuff missing was on the 24th.
Okay, but on the 13th,
Okay, let's
you
go.
met with Susan and you said she brought you a copy of those exhibits that were admitted, right?
6/13 you're talking about.
Yes, I'm talking about 6/13.
Give me a minute. Yes, so that's when she gave me copies of the receipt book. And she said she made them, that's who said I know, but she made them for her protection.
But the response to the subpoena had not been
Right.
submitted yet, right?
Right.
So after June 13th, did you meet with Susan again?
Let's see here.
Or let me ask it this way. Was the June 13th meeting with Susan the only time she provided you documents?
No. We have, on the 24th, she gave documents of July.
Which, what's the problem?
It's noted here.
What are we talking about?
So I believe that we can narrow it down without my testimony, that sometime between, so you just demonstrated that Susan Tristan made copies of her receipt, not because she's made a comparison, it's just she wants to give him copies. That's not because she knows that they're missing or anything. So then,
But hang on, what are these records of?
This is the
These records are-
grand jury subpoena, Judge, that we've been talking about in objections since the beginning.
Well, I understand that. I understand exactly what the objection is. I understand what the state is trying to purport that these are, but he just said he has no idea.
Les Kanowitz testified that he gave those documents to me in response to the grand jury subpoena of June 11, 2019. And then I might not know the exact date that they were handed from me to Ranger Freeman, but we know it was before July 24th. Because that's when the comparison was made, and that's when Susan was able to tell me that there were missing documents.
So let's take it from where Les did testify that he handed that exhibit to the prosecutor. What is your objection?
But he testified he didn't know where he got it from, Judge. It wasn't clear.
No, that is not.
Well, yes, it was, but and she made a representation to the court that she handed him back to Les, not to Freeman.
No,
So,
that is.
yes, Don, yes, you did. I mean, and the record is clear about that. She said she handed him back to Les, and for him to go back and get a business record affidavit, but yet then she makes a comment that she scanned them in, and then Les goes and gives them to Freeman, and then I guess Freeman gives them back to her. I don't
So
know.
is there evidence of the day that you scanned them? Because if Les gives you 211 pages, and then you have to scan of 211 pages,
I'll have to look.
that is pretty good.
I guess just because I gave them back to Les doesn't mean I didn't also give them to Brad. Just, I can give them to two people at the same time.
Right now, I'm just concerned with the authenticity, okay?
So-
Whether you guys argue those are the worst records ever at closing is not my business, but we need to do one step at a time.
But Les also testified that he did say who he got them from. He either got them from Constable Vela or one of her staff.
Yes, he
so
did
he
say
did
that.
say the source. So why would they be giving him documents for no reason? It was in response to the June 11th, 19.
And based on the only thing missing is if you have the where you scan them, because I'm sure that I've never worked for the DA, but I'm sure somebody brings you evidence, you guys take it to scanning or something.
No, it doesn't exactly work that way.
So then how do you record? I received something?
Well, unfortunately, in this case, Les Kanowitz did not follow the directions, so he came to me instead of Brad, and he, Ranger Freeman, and then he also didn't provide a business records affidavit, which is why in turn I had to return them to him and have him start over again.
But she represented to the court during a hearing outside the jury's presence that she scanned them before that happened.
Yes.
I did. I just have to find the scan date. I'll have to go into my computer this evening and see if I can find it.
If I can make it clear to the court, we were never provided with a copy of that scan in under 3914 discussion.
Absolutely, they were provided with every single thing I have.
Yeah, I mean, I think that's an easy thing to resolve. If she scanned it and,
We were provided with a copy of what
where does
Mr.
the scan
Freeman
go?
scanned.
I'm not.
The scans are all with me. I did my own scanning. I have a
Well,
scanner.
that was
in
my
office.
question. That
Yes,
was my
I
question. Do you
did
have a
scan it.
clerk that scans
No.
it and it goes on some
We're
sort
in
of
a small
server?
division. No, we're in a small division. We don't have all of those resources like everyone else.
I mean, that's easy to find, I think. If you
Yeah,
can, you can just
it'll
find
be in
it.
my hard drive. I'll look.
Okay, so we established that it's the same 211 pages that she received, that she
We
got
have-
back to scan to.
I don't think we've established that, Judge. We've
No,
never-
I'm saying if we can get there with the scan, what is your objection?
Well, I guess if I could give the court further information, just for the court, that
that we know the only copy of those 211 pages that we received was from a scan that Ranger Freeman apparently did on July 30th. You know it's July 30th because it's included in, the date is included in an email. I guess it's scanned to an email. And so we have one copy. But obviously for our defense, it's important to know and have been provided beforehand what copy was given to her, and that has never been provided, so that we could compare
But if
those
she
two.
scanned it, we have it. I mean, she has it. If she scanned it, she has it. And you can compare what Freeman gave you and...
If she scanned it and she has it and we weren't provided with
I
that,
would provide everything to them. That's why they have.
I'm not, so that's not an issue of admissibility. That is just, you know, you can make your objection that under 3914 you didn't get it. That's fine. I'm not delaying this. If she scanned it and it's the same set, I mean, we're going forward. And then you can argue, you know, wait, which is what you're arguing right now.
yes, Your Honor, it's just, I guess from just so that to prepare the argument is that we would rely on kind of the same thing we relied on with the wiretaps, which is that it's not a continuance that we're asking for. It's that the record should be excluded if they were not provided to us under 3914. And that would be the remedy to a discovery violation.
Well, that's assuming that the records are different. Right now, I am interested in if it was the same set of documents that she scanned and the same set of documents Freeman scanned.
And then our issue,
to all of you.
And then our issue would be that we would never be able to get there, because in order to get there, she would have to be a witness in front of the jury, and she would have to testify to what she scanned, and she would have to testify to that, to all of those things, and she can't do that. And so now we're back to the point where a witness is the advocate, and this is an important part of the chain, because the chain ended when it came from Les to Dawn and it got into the state's custody. This chain ended.
It did not ended.
Les testified that he handed that exhibit to her. He did say that.
And that's the end of the chain.
And he reviewed it.
But then now it's going other places from the end of the chain, from when it got into the state's custody. And so that's what we're...
Now, the part that you're talking about has to do with the beginning where Les gives it to her. At some point later, Dawn and investigator in the office give it back to Les. They comply with the, response to the subpoena with this affidavit, or these are the sample forms of affidavit. Les testified after that. He delivered the exhibit that was already admitted, that's a 3-pager, and the 211 pages. Les did testify to that. So even if there was a break, I'm saying it's not substantial. So I want to know that that scan was there, and that it's the same documents.
Yes, Your Honor. I will say that with the investigator when he testified, because it was a little confusing, and I'm talking the record here. His testimony dealt with a meeting that happened in late August. It did not deal with any of these documents or anything that had to do with this. What he was referring to was the absence of business record affidavit, which occurred after the second subpoena issued August 20th, which occurred far, far after.
Nobody asked about that of Scott, so you may have to bring him back. Nobody asked him that.
Well, when he testified, to the conversation he heard or talked about, he testified that it was the absence of business records affidavit. And that conversation, as Don will admit, did not occur until August of 2019. This June stuff, that he did put that on the record, and that was a completely separate thing with Les and that conversation than what we're talking about here, June 11th subpoena, somewhere around June 29th to July 1st when it was turned over.
Les testified that he received that absence of business record affidavit from us.
He did say that.
I agree, but he received it in August. None of this had anything to do with what happened when Les brought the records to Dawn.
I was not meeting with him anymore. He was going directly to the ranger.
He did testify that too. That was the last time that he met with Dawn, was when she gave him the records back. So, the issue is, let's see if the scan is there, and then you still state you're going to have to overcome how you get that in without Dawn testifying. So we'll have to cross that bridge tomorrow. I'll give you guys some time to research how you get those in without Dawn proving them up. All right, so Ranger Freeman, any questions of the witness before I excuse him for the day?
No, not in this issue yet.
You remain under the same instructions, and we'll see you next week. Thank you. We're going to be at recess until 10:30.
And Judge, just to be
and this is just,
Still on the record?
yeah, still on the record, and we still have the grand jury secrecy objection that we've been maintaining throughout. We're going to still be arguing that, and so, just so that you're prepared to rule on both.
Well, it's never been established if at the time that he showed the records to the witness, if the grand jury had already considered those very same records, the response to the subpoena. So if the grand jury was convened, but they're not specifically taking up matters as to this investigation, has the confidentiality kicked in or not?
Yeah, and it may be just kind of as officers of the court. Yeah, because that's our argument. It's communication to the grand jury, which is supposed to remain secret, but these records that are provided. And so once these communications are provided, and I think everybody can establish this well before any indictment, because the indictments are all occurring in October.
Do some research, and if you have something that says that if the witness violates that confidentiality, those records don't come in, I'll consider it.
Yes, Your Honor.
I just,
Understood.
on that basis,
But we're talking so much about the other thing, I just didn't want to get about that.
okay. All right, we'll see you guys tomorrow at 10:30.
Thank you.
Can you put these exhibits up? Over here.
And I think it's